potential historic properties, there was existing vegetation that would screen them and provide some buffering. There's some explanation in the letter about how at that time the division was only getting, there was no process for sending individual applications for review, so they'd come in batches as a courtesy. The department would send over batches of them. And somehow they missed this historic home, which does exist, is on the register. And so they reviewed it and determined that there would still be no undue adverse effect because of that vegetation and the fact that there's a plan, which I apologize I haven't had a chance to see. I only found out after close of business yesterday. But apparently there's a plan that's going to augment the vegetation. I'm sure the project or somebody else knows about that. So there's a letter dated yesterday, July 6th, filed with the clerk. And as I said, I don't know that people have had a chance to see it. I mentioned it to Ms. Hill when I first got here. Jamie Duggan from the division is the knowledgeable person about historic sites, if any. If there were a role for that today, or if time were, extra time were the more effective approach, that's up to, I would defer to the parties for review. But as a preliminary matter, I just wanted to raise that because I don't think we really have a role in what seems like an order of witnesses and testimony. I wouldn't want us to sit till the end of all that to say, hey, we're here, and maybe more time is needed.
And DHP is not a party to the case at this time.
I apologize because Dale Azaria, the counsel that usually does the DHP work, is on vacation. And so I found out after the end of business yesterday. I don't know if they've entered an appearance or not.
No.
Have not. Probably because their comment letter was there's no effect. So, if you may be familiar that routinely the division, more often than not, works with the parties, particularly the project, to reach an agreement about what to do, whether it's archaeology or historic sites. And then it's incorporated into either an MOU that becomes an exhibit that a party files or project files. That's more of the routine for how they appear.
So, is the plan for anyone to call Mr. Dugan as a witness, or to any of these existing parties?
Well, two things. One, I would move for continuance. I just got a glance at this letter again, this when John walked in, and much of the for example, the application says there are no historic resources, and the testimony and even the objection to testimony all relates back to this DHP letter saying that there was no effect and that there wasn't a state registered property. So much of the substantive content threaded through the testimony of this hearing and the objections and information on the application and so on. We're relying on a letter that now has substantively changed. I certainly would like to ask Mr. Duggan questions, but I think it would benefit everybody to have the opportunity for both the applicant and for us to ask him those questions, probably with, general counsel who's more familiar perhaps with the file, looking at it prior to that testimony, and to have the applicant be able to review it in light of what they've submitted and make whatever amendments are appropriate. And see if there's, like you mentioned, in most cases people work out an agreement with the department in terms of are any of the vegetative plans appropriate, are they okay with that, do they have other input regarding it. And so it just seems to be, since this hearing is so focused on the aesthetics, and this impinges directly on that, and nobody's had a chance to digest it, and I think it might involve perhaps some at least amendment and a chance to have those conversations. That's not gonna happen right here.
Mr. Burke?
The applicant would oppose any request for continuance. First, the applicant's objections to admissibility testimony dated June 28, 2016 points out that the historic nature of this home is not germane to this proceeding, which by the Public Service Board's procedural order is limited to and focused on whether the applicant is taking generally available mitigating steps which a reasonable person would take to improve the harmony of the project with its surroundings. Second, the intervener has had the Division of Historic Preservation's initial letter since the date it was issued, and apparently its counsel very recently decided to contact them and to request some form of rewrite of its letter, which they've done, and I've marked it as Sun Exhibit 13A for purposes of this. It's not elaborate. If this is going to be allowed into evidence, that is, we have submitted the initial letter as part of Mr. Moore's pre-filed rebuttal testimony. In the event, for some reason, the hearing officer decided that this issue would be allowed in at all, we're perfectly content to submit 13A. If we mark that as 13, and we'll submit this new letter as 13A. And all it indicates is, well, yeah, it's a historic home, but the project will not have an undue adverse effect on the qualities which make this site historic. And then talks about augmentation of vegetation, which is the crux of why we're here, as you know from the pre-filed testimony. So there's no mystery here. There's no reason to further delay this, and we oppose the continuance. We're glad to submit this as part of rebuttal if our objection to admissibility is somehow overruled. But we're here, you're here, we should proceed with the hearing respectfully.
I'd just like to respond in terms of contacting Department of Historic Preservation. Both my client and I have called them repeatedly over the months, and it was not until a very perhaps stern message that I left Tuesday regarding the fact that this was coming up for hearing, and we still had not had this response, and then we got a response. So there had been attempts to communicate with them or attempts to have a dialogue over the course of this time, and before I was engaged, my client as well had contacted them repeatedly and said, no, this is a mistake. I do appreciate that they're quite overwhelmed and receiving, I think Mr. Redding had indicated this came in a batch of 80 some odd applications or something for their review. So I fully appreciate that. I'm not faulting them for that, but we've been attempting to have that dialogue, and now if it's just landed and we have not had a chance to have further conversation with them or discuss what this might entail. Councilman John Kessler was said that he had seen what the vegetative plans were and isn't in a position to say what's satisfactory to the department.
I'll note that the rebuttal exhibit 13 by the division, its initial letter, this is dated November 10th, 2015. We are now here in July for the hearing. Ms. Hill may have made phone calls, that's not in evidence, but regardless, it's her obligation to, if she thought there was something inaccurate in that letter, to timely deal with it and not generate something at the last minute, which is, again, extraneous to the issue that the Public Service Board has identified for decision in this technical hearing. So, again, we urge that the hearing officer proceed with the hearing.
May I present a slightly different view? And I would like the Division of Historic Preservation to correct me if I'm wrong, but I think I understand the letter filed yesterday to really be focusing on the aesthetic impacts to a historic site. To the extent that the testimony that we have in this case that will be heard today is about the aesthetic impacts to the residents, I think the issue is the same. I think that this new letter may impact on the admissibility of the testimony that relates to historic sites, and I think it would support the admissibility of that testimony of Ms. Allen. Perhaps a pragmatic way through this would be to have DHP file a letter after this this hearing, confirming whether any landscape mitigation plan that is ultimately agreed upon is satisfactory from their perspective.
If I may, I think that is what the division offered in the letter yesterday, was that the existing vegetation will be augmented to provide adequate buffering. So they are aware of a vegetation plan, and they believe it will be augmented sufficiently to provide buffering, which is why they corrected, I would say, their November 2015 letter to say that instead of saying there's no potential effect, to say there's no undue adverse effect, because a historic site that is on the state register has been confirmed, unfortunately very late, and we're sorry about that, but it does exist, it's been confirmed, but they were aware of the plan. And the plan, as they know it and understand it, and they say in the letter yesterday, is adequate to provide buffering. But I do appreciate that it's late in time, and I'll defer to the hearing officer and the parties. We certainly didn't mean to disrupt your hearing today.
Well, I understand that there are a few landscaping plans that have been submitted as exhibits, and there's no one unified landscaping plan at this point. So I'm not sure which one DHP would be referring to. So
Jamie would know.
I think that that would be part of what we would be exploring today. So.
Do you know which one?
We're going to take a little break and come back in a few minutes. Is there anything else that we should consider when we're discussing the motion for continuance?
Only that the applicant's has no objection to the division at a later time at the conclusion of the hearing and on decision by the hearing officer to provide input as the adequacy of whatever plan is hopefully either agreed to or directed to be implemented. So that's fine with us.
That were raised. So we'll focus on aesthetics today.
Thank you. If I could, we're perfectly happy to have Mr. Duggan either right now or later advise what, if any, buffering the division thinks is appropriate, and we will do that. And so, versus us commenting on the abstract, maybe he could just briefly address that issue, and it may be a non-issue, looking at the current plan and location of the proposed array. Sure. It seems to me, if I'm understanding the hearing officer's ruling, that the parties would comment later on that letter, but I think we'd be somewhat speculating as to what Mr. Dugan intended by the use of the word buffering vegetation, as the crux of it, and maybe he could just explain that now, and it'll help inform us as we go forward, versus trying us to guess what's in his mind in writing that in relation to the proposed.
Well, I would expect that DHP would also file any clarifying comments at that time, and a motion to intervene as a party as well.
Perhaps it would be, in terms of timing, have DHP file clarifying comments perhaps coming out of information they learned in today's proceeding, and then have the parties comment on the letter as clarified by DHP's further filing, just so that what Mr. Berger is saying to the parties know exactly what it is that DHP's concerns or lack of concerns are.
That works for applicant.
Does that make sense? Okay, so let me make sure that I understand that. So we'll set a time frame for DHP to respond to any issues that are raised today and file comments enhancing what the comments from yesterday were. And then there'll be a opportunity for comments from the applicant and from interveners after that is filed. And that would be the opportunity to raise any significant issues or to request a hearing on those issues that were raised.
I think, if I may, it's hazardous to make a prediction, but knowing the details of this project, I think there is a reasonable possibility that the parties on their own discussing the historic preservation issue would be able to come to some form of agreement on it. Just looking at it, I think that's very reasonably likely. And in which case, if in their comments on the deadline that you're setting, they or some other filing indicate that they've reached an agreement and we see what it is, I don't think the Division of Historic Preservation would even need to move to intervene, because as I described earlier, when through informal efforts, applicants and in cooperation with parties reach an agreement on how to address whether it's archaeology or historic site to the satisfaction of the division, then as long as we have that assurance, it's going to wind up in the filings. That in this case, it would be that there's existing vegetation there now, and the array has moved. So if it's moved to be less impactful. If there's some additional agreement on vegetation and we've received that information and it's satisfactory, the division doesn't even need to appear because the parties have worked it out. And that happens more often than not. We simply don't have enough people to appear in every hearing to say that it's worked out. So we put a lot of trust in applicants when they say, yes, we'll include that in our submittal that we will do these things. And we see the filing and we just trust that it happens. But I think what I'm describing is a reasonable possibility that
Yes.
you may never see us appear as a party, as an intervener, filing anything. So I've seen a lot of different projects, and I don't see this as a hiccup, mostly procedural, caused by us, and sorry for that. But on the substance, I don't. This isn't one of greater significance that gives us any pause or reason to mount a big effort.
Procedurally, I want to make sure that the parties have a chance to respond appropriately, and I think that there's the opportunity for DHP to file additional comments, and if DHP chooses not to, then the parties, the interveners and the applicant could still file any comments on significant issues or requests for hearing. So I think we'll just set those two dates as a way of addressing the procedural issues.
I just wanted you to know that if you don't see or hear from us, it's not an indication of our lack of interest or negligence. It's really more a testament to what usually happens is the parties have worked it out informally to save you all time here.
So how much time should we give for DHP to file additional comments after today, if there would be need for that? 2 weeks or?
No, I don't think we would need that much time.
Okay.
We know what we know.
1 week?
Yeah.
Or-
That would be fine.
Okay.
And we don't want to delay the process.
And then we'll have 1 more week after that for the interveners and the applicant to file their
Well,
comments.
If I may again, I'm really sensitive to the fact that the division interjected late in the process here. And that almost feels like the cart before the horse. I think that if there's a way to have the parties consider the letter that was filed, I know it's marked as a potential exhibit already for today, and I understand absolutely understand that today it might not be timely to address it completely. Maybe it is, maybe it's not, but I understand that they haven't had time to digest it. But it is filed with the board, and a copy can be obtained and can be considered. And in talking to Mr. Duggan, there's not really anything else to add to that. So to give us a week or 2 weeks to comment, it just pushes things out, and we've already shown up late. So I think that unless Mr. Duggan thinks we need to add to the letter, I think we can rely on the letter, and the parties can go with the letter and decide between them, or among them, I don't know how many parties there are, if there's more to the story. But there really isn't much more from a historic preservation standpoint. And so that comment period, we appreciate being offered the opportunity, but I think all that will do is lead to us filing the same comments but stretching this process out, and we don't want to do that.
Well, I think the issue is, in my mind, that the letter refers to a landscaping plan that isn't named and isn't clear to me, so I couldn't rely on that. So unless DHP was more specific, then I'm I'm not a frequent public service board attorney, but my understanding is that, and particularly on facts of this application, that limited number of parties, limited issue, could be readily resolved among them. The division's not asking for anything, really. And so it's just a question of whether or not the project being located where it is with existing vegetation where it exists, and whether or not anything would be asked for or offered to be supplemented to that vegetation. That is, to me, a rather minor issue that I wouldn't want to see weeks dedicated to. And I think that it's spelled out in that July 6th letter filed yesterday by the division. If there's a question about the plan, I think that can be asked of the applicant, and they can explain what plan, they can reach an agreement and send a stipulation or include a stipulation, and you're good to go. I wouldn't want to see weeks assigned to that and have us be a part of that delay. Well, and the board certainly encourages stipulations when it's in the cards.
I mean, I've been on some of the bigger like Velco projects and the gas projects, and it's not so easy to say, oh, we'll reach a stipulation. But I'm looking at this solar array, and I'm looking where it is in the plan, and I'm seeing it as likely, to say this. So.
Okay. So, I think what I'd like to do is stick with those two deadlines, and it'll just give an opportunity for the procedural piece to work itself out and make sure everyone has an opportunity to be heard, and we'll certainly get into the aesthetics issues today. So I just realized we're not on the record yet at all, and we've been talking for a while. So
That's good. Well, thank you, and I just want to be clear that the division's available to the parties as they consider this issue to call, and we'll do whatever we can to help them reach an agreement efficiently.
Thank you.
Welcome.
So when we go on the record, we'll note your motion for continuance, and I'll set forth this procedural solution or procedural offering to deal with that, and to make sure that that's all on the record accordingly. I think let's get started. This is a technical hearing in CPG number NM6841, which concerns the application of Sun CSA 58 LLC for a certificate of public good for a 150 kW interconnected group net metered photovoltaic electric power system in Addison, Vermont. My name is Andrea McHugh, and I'm Utilities Analyst for the Vermont Public Service Board, and the board has appointed me to be the hearing officer for this proceeding. With me today is John Gerhard, staff attorney for the board, and I will start by taking appearances.
Jeannie Oliver for the Department of Public Service.
Richie Berger for the applicant's Sun CSA.
Cindy Hill for the interveners, Stephanie Allen and Dave
Thank you. Before we went on the record, we had a discussion regarding a motion made by the interveners for a continuance based on a letter that was filed by the Department of Historic Preservation yesterday, July 6th. Ms. Hill, do you want to state that motion for the record?
Sure, I move to continue on the grounds that the letter just presented this morning, I guess it's dated late yesterday, from the Division of Historic Preservation materially affects a number of substantive elements of this hearing, including testimony from the applicant, information contained on the application, as well as information and an objection to testimony, and it's time to digest that letter and be able to have conversations regarding its impact on the proceedings here today would be appropriate.
And the applicant opposes that motion to continue, as noted previously off the record. I'll put on the record the Vermont Division for Historic Preservation's initial letter report to the board was dated November 10th of 2015. It's been in the possession of the interveners and their attorney since that date. Apparently very late in the game, they contacted the division and received what was issued yesterday, July 6, 2016, which they corrected their mistake, and people and agencies make mistakes and said, yes, it is a historic structure, but said it with adequate buffering, there's no undue adverse impact. And as indicated by the council for that Agency of Commerce and the Division of Historic Preservation, it's de minimis issue and should be readily resolved. And again, with the focus on the scope of what's actually before the hearing officer in this matter, which is set forth in the board's procedural order, is not relevant in any event. But the way it was handled by the hearing officer makes sense, and the division can review and provide comments, and the parties can promptly comment and deal with what is essentially a non-issue.
So I'll note that today's hearing was noticed for focusing on aesthetics, and in order to ensure that there is a procedural opportunity for the interveners and any other folks to respond to the new information provided by the Division of Historic Preservation, we will have a deadline for the Division of Historic Preservation to file any additional information 1 week from today, which would be July 14th, and then 1 week after that, which would be July 21st, comments from the applicant and interveners on the issues that were raised by THP, and whether there were any significant issues could be raised at that point, and any requests for a hearing also could be made at that point. Are there any questions on that?
No.
There's also a pending objection filed by Sun CSA on June 28th. That's objecting to the admissibility of the pre-filed testimony of Charles Kelly and his exhibits, and also some testimony and exhibits of Stephanie Allen. I received the intervener's response to that via electronic mail on July 3rd. I just wanted to make sure that a paper version was filed as well. Okay, we just haven't received it yet, or it hasn't made its way to me yet.
Yeah, it was also mailed on the 5th.
Okay. Thank you. So I decided to take that objection under advisement at this time. We'll consider the objection further upon reviewing the briefs and also in light of the information that we received from the DHP and so in the interest of having the hearing go on today and cover as much as we can, Mr. Berger, you should conduct your cross-examination as if it will be admitted, the testimony, and I'll rule on that and on the objection as part of my proposal for decision, and if it needs to be done earlier, then I will decide that and do so.
Since I'm a novice at these matters, I assume that by conducting such a cross-examination, there's no way withdrawing or undercutting my objection to the testimony and the exhibits.
It's noted,
Preserving
yes.
that objection.
Yes.
Thank you.
Okay. So before we went on the record, we said that we would start with Mr. Moore. So I will swear you in first, and then we can move to have the testimony be admitted in the exhibits. Here's your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Your full name for the record.
James Moore.
What do you do for work, Mr. Moore?
I'm one of the co-founders, co-presidents at Suncommon.
In front of you is an exhibit binder which contains your pre-filed testimony and your pre-filed rebuttal testimony. Do you see that?
I do.
And the exhibits that were presented with that pre-filed testimony?
I do.
And the hearing officer has a copy, and Attorney Hill has a copy. And I'm sorry, Madam Recorder, I didn't bring yet another copy, but we can arrange to provide you with one as well. And were those, was that pre-filed testimony, those exhibits prepared by you or at your direction?
Yes.
And if I were to ask you the same questions that are in that pre-filed testimony today, would you testify in the same manner?
Yes.
Do you have any technical corrections to make to either of the pre-filed testimony, the direct or the rebuttal?
No.
In the exhibit notebook, if you would turn to Exhibit Sun 1, is that a depiction of the proposed solar array that we're here about?
Yes, it is.
And showing you Exhibit Sun 2, is that the wetlands delineation map that was prepared by Suncommon's wetland consultants, Arrowwood Environmental.
Yes.
And showing you what's been marked as Exhibit Sun 3, is that the site plan, the initial site plan for a 300 kilowatt system that would have wrapped around the wetlands and buffer area that were then identified.
That's correct.
Exhibit Sun 4, and that's is that the site plan which was designed to install the solar array as far north as could possibly be done.
Yes.
In Sun 5, is that site plan number 2, which was designed to address the intervener's concerns by moving the array further west from the property boundary of their residence on Route 22A in Addison, Vermont.
Yes.
Exhibit Sun 6, and that's the email from the Agency of Natural Resources advising that the site includes only Class 3 and not any Class 2 wetlands.
Yes.
Exhibit Sun 7 is the second wetlands delineation.
Yes.
Exhibit Sun 8 contains the emails between former Suncommon employee James Pepper and the interveners.
Yes.
Exhibit Sun 9 is that email exchanges between you personally and the interveners.
Yes.
Exhibit Sun 10 is that the email from you to the interveners requesting their input on siting and possible landscaping of the array.
Yes.
Exhibit Sun 11, that's a landscaping plan that was prepared by the consultant for the interveners, Michael Lawrence.
Yes.
And Exhibit Sun 12 are those emails between counsel for Suncommon and counsel for the interveners concerning that landscaping plan.
Yes.
Exhibit 13, which was discussed perhaps off the record, that is the letter from the Vermont Division for Historic Preservation to the Public Service Board.
Yes.
And that's the initial letter that that division issued back on November 10th, 2015.
Yes.
And it may not be in your notebook, but Exhibit 13A is the letter from the Division for Historic Preservation dated July 6, 2016, which was just received and was discussed both off the record and on the record at this hearing.
Yes.
And all those documents, except for 13A, were all copied as exhibits to your pre-filed testimony.
Yes.
I move for the admission of the pre-filed testimony and rebuttal testimony of Mr. Moore and exhibits Sun 1 through Sun 13A.
Is there any objection?
May I just ask a clarification? I believe council, I wasn't clear what I heard council say in terms of what had been submitted with the pre-file testimony. My understanding is that the exhibits with the pre-file were 1 through 11?
1 through 13. The only new one is exhibit 13A, the historic preservation.
I believe it was the supplemental testimony that
Oh, that was filed with the rebuttal as well. Have you had him look at the rebuttal? I thought you just looked at the first
Oh,
rebuttal.
yes, that's true.
Yeah, I missed something,
Sorry.
yeah.
I thought I asked him if the pre-filed rebuttal testimony was also prepared by you or under your direction,
Yes.
and the exhibits that we discussed were attached there too.
Yes.
So moved. Has-
No objection with that clarification, thank you.
Thank you.
No objection from the staff.
Is there any? The witnesses.
You were through, Mr. Ritchie?
Mr. Berger, yes.
No, Mr. Berger, I'm sorry.
That's right.
My
Many
apologies.
judges over the years have called me Mr. Ritchie, so I'm used to
I apologize,
That's
Mr. Berger,
all right.
thank you. Good morning,
Morning.
Mr. Moore, how are you?
Good.
Good. I have a question for you regarding Exhibit Sun 1, which you just identified, I believe, as being the current proposal. That is not, in fact, the site plan attached to your project application, is it?
I'd need to see the two side by side, but that is, it feels demonstrably the same. There may have been some small modifications with, I don't know if it's the panel selected as time goes on, what's available, or precise measurements, but that's where we're proposing to put the array.
When you say that's where you're proposing to put the array, was it you who submitted the application to this board back in October?
It was Suncommon, and I certainly had handed that and signed the CPG, yes.
I marked this because I didn't think I would need it. I'm just marking for demonstrative purposes only here. I'll mark this as Alan.
What was the last one? So, fine.
I marked it as Alan Cross 1, just for exhibit only. So do you have a recollection as you sit here, what plan was attached to your application?
No, I'd need to look at them and compare them side by side. I think
If I can,
that there
that's
have
fine.
been a lot of changes to this one, trying to be accommodating.
I'm just showing you the item that I've marked as Cross 1, which is a copy of your application. And looking at that, can you tell me, is this the site plan that you attached to your application?
Not this, so this is the site plan that we, one of the earlier site plans that we had submitted and were able to make changes to, in large part to accommodate the concerns. And we've moved the array north.
So I just want to be clear, the site plan which is submitted as your application for this project is actually not Sun 01, is that correct? Isn't that correct?
That is correct.
Okay, and so the site
I
plan that
would
was
want to-
submitted with your application is actually what you referred to as Sun 05, is it not? Which I believe you referred to in your testimony as site plan number 2?
Yeah, these two are very similar. I'd want to look back through all of the filings, and I think, as I mentioned, there were a number of changes to the proposed site plan to try and be accommodating since the October submission.
So the question is, what is in the application before the board? So did you ever amend this application? Have you amended this site plan that's attached to your application?
I'm not positive.
You never withdrew the site plan with the application, did you?
I don't believe we withdrew any site plans. What we tried to do as our general practice is come up with the best proposal and share that with folks who are concerned about the project and try and get to an agreement. We've certainly shared that first exhibit.
My question is the first exhibit the site plan in your application before this board?
I'd need to, it is not the site plan that was originally submitted. I would need to take time to confirm what happened and what versions may or may not have been submitted after the October date.
So is it your testimony here today, when you referred to Sun 01 as the present proposal, is it your testimony here today that Sun 01 is what you would like this board to consider as the site plan for this project?
It is the general location of the array. Sun 01 doesn't include the landscaping measures, for example, that we've offered to implement as well. So it's not, when you say site plan, I just want to be clear, that is the general location of the array that we believe is the most accommodating.
So is there before this board right now a site plan which comprises the site plan you are proposing for this project?
In Sun 1, yes.
And another question, seeing as how you have, for your recollection, Cross 1, which is the application packet in front of you. At the time on that application packet, the Suncommon representative checked that there were no historic sites in the vicinity of the project, isn't that correct?
That's correct.
And did Suncommon speak with representatives of DHP before checking that box?
I have to ask our staff.
Okay. Are you aware of any steps that Suncommon took to determine whether there were historic sites in the vicinity of the project before checking that box?
The standard practice is certainly to check registrars, and I apologize that we clearly, from the DHP letter that we got yesterday, missed this on the state registrar.
So in light of that information from DHP, would you change that information on your application?
Yes,
And what would you indicate?
that we say yes, that it is to be cited near or within any of the following resources. Near being subjective, but it's, we would err on the side of caution and say yes there.
In regards to that exhibit Sun 5, you indicated, I believe in your testimony you referred to that as site plan number 2, is that correct?
I have to look at my testimony to cross-reference that.
Let's do.
Is that in the pre-file? Is that what you-
Yes.
You want to draw my attention to it? Or I can find it.
Or I'm glad to if it's okay.
Go ahead.
Sure.
Mr. Parker.
Page 4, in that line 3, your pre-file testimony.
Can you repeat the question, please?
The item that is designated as exhibit Sun 5 here is the 150 kW array that you refer to in testimony as site plan number 2, is that correct?
Site plan number 2, am I on the wrong page? It's my cover.
Page 4, beginning line 3. Through here.
Yeah, there were a number of iterations on this project. We were trying to engage the neighbor to the project.
I understand, the question was, is exhibit Sun 5 what you reference as site plan number 2?
It does appear that that's what I'm describing there, that general location.
And you testified that, and I believe we're also on page 4, that between site plan number 1, which is listed as exhibit Sun 4, and site plan number 2, that you moved the array further to the west. That was your testimony, is that correct?
The array is between Sun 4 and Sun 5, the array did move farther to the west.
And in fact, it also moved farther to the south, didn't it?
Yes.
In fact, Sun 5, what you reference as site plan number 2, is more directly behind Ms. Allen's house than Sun 4, isn't that correct?
No, actually, due to the topography, so part of this was looking at this with an aerial image is very different than being there. So we first thought that, all right, and I was corresponding with Ms. Allen at this point. And my first thought was, let's move this as far north as possible, so as to, the direct view from the house west would be the least impacted. But due to the topography, when you move it farther north, one, it pushes it farther east, closer to the property boundary, and then two, the land rises up there a little bit, so the ability to move it south and west actually pushed it down to a lower place in the topography, and we thought that would actually be a better location aesthetically than the one north and east, so we went south and west.
So the site plan number 2, which is Sun 05, is actually effectively due west of the Allen house, is it not?
Yes, and slightly to the north.
Whereas the Sun 4 is more northerly of the house.
I would say barely, and it's closer to the east, and it's at a higher elevation. We sought input, and we're flying a little bit blind. We got no kind of...
So your communications with, or the communications of Suncommon with Ms. Allen were during the time periods of the email communications with Ms. Allen were during the time period that first the site plan in Sun 4 and then the site plan in Sun 5 were those being proposed by Suncommon, is that correct?
So what I'm looking for is the dates for the email communications with James Pepper. So here we go. So
Well, let me phrase it this way. All of Suncommon's communications
may I answer
were,
the question? We were communicating with Ms. Allen as early on by this email, August 3rd of 2015. And those communications continued as we tried to be reasonable and get input on from Ms. Allen on the exact location and/or landscaping that could help. And those communications continued until they stopped being.
and those communications ceased in September, is that correct?
I believe the email communication ceased in September. I was also reaching out to Ms. Allen. We had a few phone conversations, and I don't recall whether those were in September or not, but that seems reasonable because they were about the same time as the email stopped.
So it's your testimony that you spoke with Ms. Allen by phone?
I believe that's correct. Perhaps I just made the offer to speak over the phone, and
So you may not have spoken to her that much.
yeah, I think what happened is I offered please let me know if you'd like to connect further. The best way to do that, we could discuss over the phone, or I could come visit. I
So you did
offered
not in fact speak with her by
both of
phone,
those.
is that correct?
I don't recall whether I was successful in reaching out over the phone or if it was just the email. I certainly
And then-
offered both.
And then in October, you filed the application again with Sun 5, your site plan number 2, as the site proposal, is that?
Sun 2,
Sun 5.
Sun 5. Yes, I believe that's correct.
And you did not propose Sun 01 until after Ms. Allen's intervention, is that correct? After her motion for intervention.
I don't recall when we submitted Sun 01. We submitted, what I can speak to is internally at Suncommon. We changed our design as soon as we found out that we could reasonably do so, given the A&R confirmation of the wetlands, which allowed us to move the array to what we thought would be an even less impactful location to the north. And if you'd like the exact dates, I can look those up.
So on page 5 of your testimony, you state that you have moved the array outside of the natural view shed of Ms. Allen's house. On what basis do you state that this is outside the natural view shed?
The house is, it seems to me that the house is oriented facing west, and that there's a bunch of vegetation right there at the northwest corner of the house, and that most of the views from the house are west and southerly. And we attempted to move it far to the north as we could on that property.
Mr. Moore, in reference to your rebuttal testimony, you refer to Suncommon reaching out to intervener's attorney. In fact, you're aware, are you not, that I called your attorney asking for permission for Mike Lawrence to talk to Mike Bosher?
My understanding, I don't know who made which first phone call, my understanding is that we reached out and I know that we asked to see plans that might be available for us to consider.
And in fact, you did not give permission for Mr. Lawrence to speak with Mr. Bosher, isn't that correct?
I don't know if that's the case or not. I know that I looked at the proposal by Mr. Lawrence and we didn't object to it.
And those communications between counsel regarding that Mike Lawrence exhibit were part of an ongoing settlement conversation, weren't they?
All of this, all of our conversations, we've been trying to figure out what Ms. Allen would like and be accommodating.
And however, those communications and conversations involved a number of other elements besides the landscaping plan, did they not?
No, I think the landscaping plan and who's gonna pay for it was the crux of that, and we were in agreement.
And looking at your exhibit Sun 10, oh, I'm sorry, Sun 12. The June 7th email communication from Attorney Wonderly, who I understand is no longer with the firm. The second paragraph notes other conditions we've discussed, and those other conditions include waivers and so on. It says, I'll call you to discuss. Is that correct?
Absolutely true, but none of those, in my estimation, were a real issue or contentious, because we were happy to go along with the, my recollection is all that was agreed upon. We were fine, so I don't think that was a significant issue.
So there were other issues in discussion in the settlement besides the landscaping plan. Is that correct?
There are other things being discussed. When you say at issue, it makes me think of, was there controversy and disagreement, and I don't believe so.
And you've attached in Sun 12 a landscaping plan sketch by Michael Lawrence. And so is it your testimony here that you would be amenable to causing a landscape plan such as that one to be implemented here at Suncommon's expense?
Oh, absolutely, and we've said that, and we've tried to reach out from the very beginning, asking what would be recommended and what Ms. Allen would like, and I believe that this is the first opportunity that we actually saw a request and recommendation, and we absolutely are comfortable with planting apple trees, I believe is what was suggested here on the Ms. Allen's property, or on the Boudreaux side of the line as well.
All right, I think I'm through with Mr. Moore.
Thank you. Mr. Moore, the Public Service Board in its procedural order entered April 7, 2016 in this matter, said at page 3, and I quote, "Under the revised design, the project would be located 552 feet from the neighbor's residence," close quote. Directing you to Exhibit 23. That's a filing responding to Ms. Allen's motion to intervene, and stated December 7th, 2014, correct?
Yes.
All right. And
Point of clarification, I believe that this should be 2015. Is that correct?
Yes.
thank you. Stand corrected. Typo. So if you turn to page 3, it talks about the proposed arrays, as originally submitted, were approximately 224 feet from the intervener's home, right?
Try this stuff together as I'm thoughtful. Yes.
All right, and then if you turn to the next page,
Yes.
in the paragraph, a newly designed array is attached as Exhibit C. It moves the proposed array north of the currently proposed site while remaining on the same parcel of land. This new location will move the array further away from the intervener's home while keeping it at a lower elevation and maintaining a distance of 552 feet from the intervener's home and approximately 418 feet from the nearest road, correct?
Correct.
And if you turn to the next page, that was provided to all of the parties in the town of Addison, the intervener, proposed interveners, et cetera, right?
Yes.
All right. And turning to the second to last page, it shows that there's a tab on it. And that shows the site of the solar array as currently before the Public Service Board, which is your Suncommon Exhibit 1, right?
Yes.
And after providing that to the interveners, did they ever indicate they had any interest in discussing any type of mitigation or landscaping under this new revised location that you worked out to move the solar array further north and further west from their home?
To the extent that we had some conversations about, for example, exhibit, whatever it was.
But that's in June of this year. I'm talking
Oh,
about
yeah.
before that.
No.
Thank you. I don't know if I need to offer 23, but I will, just so that it's.
Yeah, let's just do that so that the record is clean and has everything
That's fine.
needed.
We'll offer exhibit 23, Suncommon exhibit 23.
Are there any objections?
Well, I don't have objections. We've had this conversation before in net metering cases, which is a problem. We have the administrative record, and then we have the hearing record, and the question is how things come in. So I would not have an objection to this, but I would then like for the rebuttal comments and some of the other materials related to it that were in the administrative record to then also come in. So I don't know whether we should come up with that, and perhaps I should just speak with the other council off the record and see if we have a list, and
Okay.
if there's any objection to those other materials coming into the record. Is that,
Glad to discuss it.
I think it would help in terms of having everything being numbered so that everyone's talking about the same pieces of paper and information in the same way. I see your point.
right, it gets confusing because the administrative record of the comments before a hearing was granted and offered are not necessarily part of the record. This obviously becomes critical on appeal as to what's docketed as part of the record. So Mr. Berger just moved in one of those items from the administrative record, and so I would propose that, or I guess I would say that I would object if the chain of communications that were part of that administrative record did not come in its entirety.
Should we take a break after the next witness and so that folks could discuss which pieces of information would like to be admitted to the record, and then once we get, when we reconvene, there could be a motion to move to initials, so that everyone's on the same page.
Yeah, that would make,
The other alternative, which I think is what we've done in past proceedings, and may not be ideal because of the numbering issue, is when parties file their brief, they attach certain administrative record documents as exhibits and ask for their admission. And there's no flawless process for this. It's something that's not anticipated by the rules.
objection to, on a break, getting together and discussing which items would be offered into evidence?
I don't object to the discussion, I just don't know if Cindy has something in mind currently, or if she wants to drop you a letter in the next day or two.
Right, no, it's just that the item that was just proposed for admission is part of a chain of correspondence. So there was the application, a response and comments, and this was responsive to something else, and then there was another file that was responsive to that all before the hearing. So I would like to put that whole chain in its entirety, and then you're correct, we need to, it would make sense to number that in some sequential.
We're not going to discuss it anytime.
Okay, so when we take a break, you all could discuss it, and then we'll take it up when we come back when we reconvene.
I guess one issue would be to the extent that those documents contain commentary or information about issues that are not being heard in this proceeding. Is there a way to ensure that those exhibits are only considered for private motions?
And I think
That's a good point, because it is a very limited scope here.
And that also speaks to the objection, the pending objection that hasn't been made. So perhaps we could at least number them, and then the decision could be made subsequently on whether to admit them.
I will note that I offered Exhibit 23, the testimony is in, but I offered 23 because it was in redirect from an area of cross-examination, so they would be pejorative to that in any case to the addition of 23.
On the other hand, if you submit a part of a document, you're entitled to have the entirety of the document.
Evidence to a document, not one to a document, it's from 201.
But, no, I meant in terms of, yeah, that was responsive
Yeah.
to Attorney Oliver's comment about portions of these documents are relevant and portions are not.
And I guess the hearing officer has the discretion to just consider what's relevant to the issues. It's not really an issue.
Okay, so I'd like to give folks a chance to discuss this off the record at a break, and let's see what we come up with, what you all come up with off the record. So we'll have this Exhibit 23 be pending for now, and I also, there's Cross Allen 1, which you didn't move to admit, but
No.
it's the original application, which would fall into this
Right.
category. So perhaps you can all discuss that after. Okay, so let's put that aside for now, and Mr. Berger, do you want to
Yes, Mr.
continue?
Busher?
Are you finished?
Yeah, I'm finished with Mr.
Moore?
Moore.
Let me.
Once she's done, once she's done.
Are there any other questions, Mr. Moore? You're excused.
Thanks.
Thank you.
I think I'm gonna go there.
Then move, I should go closer so I don't have to yell across you, okay?
Mr. Busher, can you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Your full name, please.
Michael J. Busher.
And what do you do for work?
I am a licensed landscape architect in the state of Vermont.
You have in front of you the document titled Pre-filed Testimony of Michael Busher in this matter.
Yes, I do.
And Was it prepared by you or at your direction?
Yes, it was.
And if I were to ask you the same questions today, would you testify in the same manner?
I would.
Now, I'm not sure if we were on the record or the hearing officer was present, but you had a couple technical corrections to make to the document, and I want to make sure that the hearing officer has them. And specifically, page 3, at line 22, the language "or the Adirondack Mountains" was repeated in the typing, and you want that to be struck. So the sentence ends after Route 22A.
That's correct.
And then the next page, page 4, at line 22, when this was typed up, it says, "When looking due east toward the Adirondack Mountains," I think we can all recognize that they're west of Route 22A, correct? So east should be west.
That's correct.
All right. Any other corrections other than those two?
No.
All right. And you have also in front of you some exhibits. First is Sun MB1, and that's a copy of your curriculum vitae or resume, correct?
That's correct.
And exhibit Sun MB2 is a demonstrative exhibit showing views of the project from various vantage points, and is it not?
Yes.
All right. And is it, both of those exhibits were copied as exhibits to your pre-filed testimony?
That is correct.
Ms. Hearing Officer, I would like to move for the admission of the pre-filed testimony of Michael Boucher and move the admission of exhibits Sun MB1 and Sun MB2.
Any objection?
No objections.
No objections. They're admitted.
Ms. Hill, you're a witness?
Thank you. Good morning, Mr. Fisher. How are you?
Good.
Good. I'm looking at your pre-filed primary, you had no rebuttal testimony, is that correct?
That's correct.
Okay, so I'm looking at your pre-filed testimony on page 3. You note that the footprint of this project is small, involving approximately 1 acre. The term small is a relative, isn't it?
That is correct.
Okay, and this is actually about as big as a football field, isn't it? A little bit bigger. American football.
100 yards. To be honest, I can't even tell you how wide a football field is, so I would say it's approximately the same size.
Neither can I, but this is about 330 some odd feet long, is that correct?
I would have to measure it specifically.
All right. How does that acreage compare to the footprint of the Boudreaux's house and Dr. Allen's house?
The specific footprint of the structure, I would say it's larger than the specific footprint of the structure.
And you also note on page 3 of your testimony that the land on site slopes downward to the west. It's actually more of a bit of a drop-off, isn't it?
There is a pronounced drop-off behind the structures at the backside of a little bit of yard behind both of the structures along 22A to a lower portion of the property.
Okay. Do you know about the elevation of that drop-off?
I could not tell you off the top of my head.
Okay. And the area where the array is now proposed for construction is not flat, is it?
There is some undulation to the specific location of the array.
Okay. And is there a rise towards the middle of the array?
I would say that is correct.
And you noted on page 3 of your testimony, I'm looking at line 20, that the panels would sit, quote, low on the horizon. What did you mean by that?
The general elevation at the location of the array is lower from the vantage points that we were specifically looking from, which most specifically is from the abutter's house. But also, we may note that it's lower than Route 22A. So in relation to those areas, it's lower in elevation.
And on page 4 of your testimony, and I think, was it at 4? Oh, perhaps I'm incorrect. I think it was at the bottom of page 3. You noted, and I think there were some other
Could you
times.
just give us a
I'm sorry,
line
bottom
number?
of page 3, 21, line 21 or so. You note that this project will not, quote, obstruct the views. But an element does not need to obstruct a view to have an adverse impact on it, does it?
It does not.
And on page 4 of your testimony, you utilized, I'm looking for the one here. Oh, here it is, line 18. You utilized the same phrase as in Mr. Moore's testimony, that this is outside of the natural view shed. How do you define the natural view shed?
Just for the record, it says natural westerly.
Natural westerly, which is the correct direction, as we have already established, yes. The natural westerly view shed. What,
So I think, I believe almost everyone in this room was at the site visit to the property. And generally, when you're at the rear of the abutter's house, that most views are oriented more in a westerly direction, and that views are not as natural in the area of the project or to the northwest.
and so when standing at the back of Dr. Ellen's home and looking westerly, what is the range of that view shed in terms of degrees from left to right, or that would also be south to north? What's the degree range of that view?
I guess I would need some more clarification on what you're asking.
Well, when you're looking westerly from the Allen house,
Mhm.
you see quite a sweeping view. Would you agree with me? It's a sweeping view of the
I would
Adirondacks?
agree.
And that view of the Adirondack Range is viewed from some point at the south to some point at the north, is that correct?
That's correct.
And what is the angle of degree of that?
I cannot tell you that specifically.
Do you know what is the ordinary degree range of vision?
There are several different focus areas in vision. Going off the top of my head, for your acute vision, a 50 millimeter photograph taken on a single 35 millimeter SLR camera is typically accepted as a standard to most accurately represent what is generally the focus area, but I cannot tell you the exact angles off the top of my head.
And looking straight west from the back of the Allen household, at what angle from that straight west line, at what angle north would be the far end of this solar array?
I would say the
The far westerly corner.
far westerly corner from
Off of a line running due west. From the Allen, from the deck behind the Allen house.
from the deck. I would say it's in the range of approximately 45 degrees.
And you'd agree with me that the sweeping range of that view shed, of the view of the Adirondacks, is part of, is an element of its scenic quality, isn't it?
I think that the overall scene comprises part of the scenic quality of the area.
And would you refer to that view as highly scenic?
I would say it's highly scenic, yeah.
Would you refer to it as an intact landscape?
It's definitely a working landscape.
By which you mean?
That there is signs of human interference and involvement in that landscape. There's residential development, there's agricultural uses.
And you'd agree with me that vegetative screening is a commonly available aesthetic mitigation measure, wouldn't you?
I agree with that.
You would also agree with me, would you not, that the color and form and texture of this array is in sharp contrast to its immediate surroundings?
I would say when looking northwest from a butter's property, that the view from the rear of their house does not include similar colored shapes, colored forms, textures
I think I have nothing further from Steve.
No further questions?
I have one question for you regarding your testimony. You say that screening the project near the array would do little to further reduce the already minimal visual impact of the project. Could you explain that a little bit more regarding the impact of screening close to the array?
So from the abutter's property, any effective screening would have to be basically along the southern and to a lesser extent eastern side of the project. There is height restrictions that are applied to vegetation that's planted on that side as a result of potential shaping of the array. Typically, if we're up close to the project, we're required to keep plants in the 8 to 10 foot range because of the angle of view, and more specifically the vertical angle. You're looking down onto the array slightly, and that any vegetation right direct against the south side of that project is probably not going to be effective to screen the array because of the angle you're looking down towards the project. You'll basically see over any proposed planting right along that edge of the project.
Thank you. That's my only question. Do you have any questions arising from that?
No.
Nothing further, thank you. Thank you.
Okay.
And that's some of the applicant's witnesses.
Okay, let's take a break, and that'll give you all a chance to put together any other, exhibits to offer.
Thank you.
And let's take, 15 minutes, so we'll come back in, or, 15 minutes.
It's actually a
sufficient?
parking meter feeding
Okay,
break.
okay.
So perhaps
So we'll
20.
say 11, we'll say 11:30. Okay.
Thank you.
Thanks. Ms. Hill?
Thank you. In the intervening time, we talked about those items which are in the administrative record prior to the PSB procedural order and how they were to be incorporated, if at all, into the record of this hearing. We noted that in this particular case, there are really only four distinct sets of items prior to the procedural order. We had discussion amongst council regarding the issue of relevant and irrelevant content in those documents, and here is what we came up with. We determined that those four sets of items, which I will read out in a moment, could be labeled as joint hearing exhibits, that they be admitted as exhibits with the portions of the content that would then be referenced as either in testimony or in brief be incorporated as evidence into the record, subject additionally to the hearing officer's determination as to relevance on those referenced portions. Is that accurate?
In the context of what the board's procedural order of April 7th, 2016 establishes as is relevant to those particular documents.
So in other words, we'll submit them as four joint exhibits, and then the content would be admitted as evidence to the extent that those portions of the content are referenced in testimony or in briefing, subject to your ruling on relevancy. Those four items are, number one would be the Suncommon application packet of October 8th, together with a correction letter of October 12th. This was previously referenced as the Allen's Cross Exhibit 1 and not moved for admission, but it is the same item. Joint Hearing Exhibit 2 would be the Allen House submissions of November 6th, and those include a comment letter, a motion to intervene, and an appearance. Joint hearing exhibit number 3 would be the Suncommon response to those comments dated December 7th, 2014, which has been corrected to 2015. That has also already been referenced in testimony as exhibit 23. And joint hearing exhibit number 4 would be the Allen Howell reply comments dated January 6th, 2016. We determined that at this moment, I think nobody had an extra set of those at the table to mark, and before we leave here, I will request, assuming the copy repairman has left, I will request that the PSB staff allow us to make a copy of those to be marked as we have just listed that.
Okay, so is the idea is to not admit them at this time and to handle them in the same way as the objections, or to admit them at this time? Can you just state that again? When you said admit to the extent that they're used in the briefs, is that?
They're exhibits that we're all referencing to the extent that content within them is referenced in testimony, such as
Okay.
Mr. Moore just testified to portions, and I think Mr. Berger referred him to a particular page and sections and an attachment to it. So those portions, having been referenced in testimony, come into the evidentiary record. In our briefings as well, we may refer to, any of the parties may refer to those items, and so this way we're all referring to them as the same thing. And to the extent that we refer to them and you deem our reference to be relevant, those referenced portions would also be considered in the evidentiary.
Is that okay with the department?
That's fine for the department.
It's fine for the applicant, with the understanding again that the hearing officer will make determination as to which items in any of those joint exhibits may be relevant with respect to the limited issue before it in this matter per the board's procedural order of April 7, 2016. For example, there's lots of talk about wetlands by the interveners and their various filings, and the order of April 7, 2016 flatly declares no undue impact, no wetland issues. So that's just an example of making sure that stuff extraneous to the central issue, the sole issue before the hearing officer, irrelevant or non-germane items in these various conglomerations aren't relied on or taken into evidence.
Okay, so let me just confirm. So the exhibit marked as 23 has now been replaced by joint 3. Okay, so that one we will leave aside, and we will admit joint 1, 2, 3, and 4 to the extent that they are referenced in testimony, and the parties may refer to them in briefs, and the full admission is subject to my determination of relevancy at the time that I work on my proposal for decision. Okay.
Thank you. And I remarked 23, Suncommon 23 as joint 3, so I can
Okay, excellent.
save us some
There's
photocopying
one.
right there.
Thank you.
Okay, I think we're ready to proceed with your witnesses.
So I would call Stephanie Allen.
Ms. Allen, do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Sorry. Thank you.
Can you please state your full name for the record?
Stephanie Allen
And where do you live, Stephanie?
in Addison,
The address?
7020 BT Rutland Way.
And what is your line of work?
I'm a minister.
And you have in front of you an item that's identified as the pre-filed testimony of Stephanie S. Allen.
Yes.
And was that testimony prepared either by you or at your direction?
Yes.
And if I were to ask you those same questions on the record today, would you respond as you have in this pre-filed testimony?
Yes.
And contained within that pre-filed testimony, in this instance, there are exhibits that are actually paginated within your testimony. Is that correct?
Yes.
And so in regards to the exhibit, on page 2, marked as SA01, the exhibit on page 3 marked as SA02, the exhibit on page 4 marked as SA03, the exhibit on page 5 marked as SA04, on page 6 marked as SA05, on page 7 as SA06 and 07, on page 8 marked as SA08, page 9 as SA09, and page 10 as SA10. Were those similarly prepared by you or at your direction?
Yes.
And do they support your testimony that's been submitted here today?
Yes.
Okay, I would move the admission of Stephanie Allen's pre-file testimony, as well as the exhibits SA2 through SA10. Do you have those up here? Yeah, the exhibits are, the formatting was the exhibits are within the testimony.
Okay.
Yeah, you did the pre-file. I have another copy.
Yeah.
We can check.
Why doesn't that? Okay, so I'll mark yours out.
Oh, yeah, okay, so it's in the beginning.
The exhibits were wound up in the beginning. I apologize for the formatting. It just happened that way.
I'm easily confused. Okay.
I was looking at ours later. Okay. Sounds good.
I apologize. Okay, so I have moved that admission.
Okay, Mr. Berger?
Subject to applicant's objection to admissibility dated June 28, 2016, as it applies to this. No objection, although I do have one question as to SA10, if I could ask that as a preliminary matter. Ms. Allen, good afternoon or morning.
Afternoon.
And SA10, can you tell me when that was taken? That photograph?
I don't know. I couldn't tell you with accuracy.
There's a house, and then it looks like an addition or a garage. There's something on the roof on that. What, is that a solar panel?
I think that is, yeah.
No objection.
We can't see from,
The color exhibits were they were submitted both in print and in PDF when the pre-file was filed, and I do not have additional color photocopies. We do if you like.
this picture is better. This version is just very dark, so. Okay, it's fine. Okay.
That's okay. Dr. Allen, have you seen the 3 landscape mitigation plans prepared by Mr. Lawrence? They are labeled Allen and L2, Allen and L3, and Allen and L4. Just the 3 different options that are being proposed.
I'm sorry, may I interject? Did we admit the testimony then, subject to the objection and subject to my response to the objection? Was it?
Oh, sorry, these are your exhibits.
Right, no, I didn't think that her testimony had actually been.
Oh,
yeah, let's
just
just
say
handle
on the
it.
record. I thought you were,
Sorry.
had jumped ahead. I just want to make sure that was clear.
So, we'll admit Dr. Allen's testimony, subject to the objection filed by the applicant. And, I believe that the objection refers to the exhibits 1, 2, and 8. So exhibits 3, 4, 5, 6, 7, 9, and 10 are admitted, and the objection is noted on exhibits 1, 2, and 8. Okay.
Can I continue?
Sure.
Okay, sorry. So there are the 3 landscape mitigation plans. They presented in Mr. Lawrence's testimony, which has not been admitted yet, but they are Allen ML2, Allen ML3, and Allen ML4.
Yes.
Have you had a chance to review those?
Not really.
Okay.
Not extensively.
Yeah. The reason I'm asking is I just wanted to understand if, from your perspective, there was a plan among those that is preferable to you, to your interests.
Yes.
Okay. And which one is that?
That is, it's ML02, I believe.
Okay, that's the one where the trees, the proposed mitigation, 9 trees would be on your property.
Correct.
Okay, thank you, that's all.
Thanks. Mr. Berger?
Thank you.
Across the room.
Ms. Allen, could you tell us the date that you first accepted the invitation or request from applicant Suncommon to discuss possible landscaping or shading for the proposed solar array?
For which proposed solar array? Exhibit Sun 4?
Any of them?
There is none for Exhibit Sun 1.
Here my question, if you would. Tell us the date that you first accepted an invitation from the applicant to discuss possible landscaping for any version of the proposed array.
That I accepted or I had one? I'm confused as to the question. So Exhibit Sun 4, I was offered a discussion. I did not respond.
So if I ask you again, is there a date you can give us when you accepted an invitation from Suncommon to discuss possible landscaping for any proposed array? Can you give us a date, first date?
No.
Let me hand you some exhibits if I could, Ms. Allen. If you turn to Sun Exhibit 8.
Yes.
All right, so there's some emails, and there's a James Pepper who used to work for Suncommon, and he emailed you on July 31st of 2015. You see that there?
Yes.
Okay. And he says, "Hi Stephanie, thanks for speaking with me earlier today." So was that in person or by phone?
He called my office.
Okay. So he said, "As I mentioned over the phone, we ran into a wetlands issue with the previous design and had to reconfigure the array. This design does not account for the new setbacks required by Act 56, so even this one will have to be tweaked a little. I thought it would be better to get this to you sooner rather than later so that we can begin discussing ways to decrease the visual impact from your house." I read that correctly, right?
Yes.
"If you could please provide me with your concerns, I will bring them back to my team and try to work through some options." Yes?
Yes.
And your response the same date was, "Our concerns based on the proposed drawings is our entire view will be solar panels," and you ended it, "We are not in support of this plan." Correct?
Correct.
All right. And then in August 27th of 2015, you emailed Mr. Pepper, and you also sent a paper version of that email to Jeffrey Kaufman, Chair of the Board of Selectmen for Addison, Vermont, correct? Okay. And if you turn to the next page, you wrote in your email, "We were told by the Boudreaux," and that's the family that owns the farmland behind your house, right?
Correct.
And by the way, you don't own a view easement.
No.
And you bought the land and the property, your house, what, March 2014?
February 2014.
So you lived there at this time for just about 15, 16 months?
Approximately.
And when you bought the house, there was a solar panel on the roof?
No, there was not.
All right, so let me show you Exhibit 40 and ask you if that shows your house.
It does show my house.
Okay, and does it show a solar panel?
It does. That's prior to purchase.
Okay. And so the prior owner had solar panels on the house, this historic house that you bought, correct?
Mounted, correct.
On the roof. And it's your plan to use those solar panels again in the future, as you've written?
Possibly, we don't own those.
We offered 40.
As a cross exhibit,
Yes.
Mary Jackson.
No,
Submitted, it's exhibit 40.
Thank you. All right.
Can you just put a sticker on it so I don't lose track?
I do have a sticker on it.
Oh, okay, that's fine. I don't know if I want to see that, thank you.
Thank you. All right, so again, you had a phone conversation with Mr. Pepper, he sent the email, and your response was, nope, we're not in support of the plan. And then in August,
Well, there's an email before that.
in August 2015, you wrote, and I'll quote it, "We were told by the Boudreaux that a new plan would be sent to us. However, we would like to reiterate that we are opposed to any solar array being placed on the land in the attachment on the property of Bernie and Lori Boudreaux," correct?
Yes, but you're missing an email in between.
But did you answer my question? That's
I
what you
did,
wrote.
yes.
Okay. So your view was no solar, period, right?
In that section, referencing Exhibit Sun 3, yes.
So that's it. No matter how it's laid out, size of it, you didn't want it in Mr. Boudreaux's field.
I don't know that I would say that.
Okay, we'll get to that then. So, and you wrote in the same email that you sent to the select board and to Suncommon, quote, "We feel very strongly about this and will fight against it if an application for permit is put forth. We have considered, in our opinion, our position unchanged." So you're pretty adamant that you don't want solar array in that field owned by the Boudreaux and who have owned it for many, many years. True?
I would say we're leaning towards that,
Leaning towards opposing it?
yes.
And if you would turn to Suncommon Exhibit 9. And you, on August 28th of 2015, got an email from James Moore, who's seated here, right?
Correct.
It says, "Hi, Stephan. With James Pepper's absence, I'm hoping to work with you related to your concerns about a solar project on your neighbor's land. I'm happy to discuss the questions below. I'm hopeful, and that references the letter you wrote to Mr. Kaufman, the chair of the Board of Selectmen. Again, I'm hoping to work with you related to your concerns about a solar project on your neighbor's land. I'm happy to discuss the questions raised below. I am hopeful that with a thoughtful design and a better understanding of our process, that we can address many, if not all, of your concerns. That would be our goal. If your position right now is going to be one of opposition to your neighbor installing solar no matter what, then we will respect that. If that is the case, we would still like to engage with you to help you better understand our community solar program and get your input on the best possible design if we do move forward with the project. Please let me know if you would like to connect further and the best way to do that. We could discuss over the phone. I could come visit, right?"
Correct.
So he offered to talk to you on the phone, he offered to come visit you, and you declined to meet or speak with Mr. Moore, true?
I believe I said I prefer to answer initial questions through email in my next email.
Right, but isn't it the truth that you, throughout this, declined to meet or speak with Mr. Moore because you wanted a paper trail, right?
I don't know if that's accurate through the whole process. I do believe I said that. We have a lot of children, and it's easier for us to read something on paper than to have a phone call.
Let me just rephrase my question again. Isn't it true that you didn't want to speak or meet with Mr. Moore because you wanted to have a paper trail, as you call it, right?
I wouldn't say that's true through the whole process, which was your initial question.
Well, it is at this time frame, August of 2015, right?
I said we prefer, yeah.
Would you turn to your pre-filed testimony at page 18? All right, see page 18, line 1, in your summary of these contacts that you had with Suncommon. 8/28/15, Stephanie responded via email asking procedural questions. Quote, "We declined the offer to meet or speak on phone because we wanted a paper trail," close quote. Did I quote that exactly right?
Yes, you did quote that correctly.
And that's your sworn, you swore to the truth of that, right? Okay, thank you.
I'm sorry, what was the answer?
Yes.
Thank you.
Thank you.
And so you did have some more email communications with Mr. Moore, even though you weren't willing to meet or speak with him, right?
Yes, we did.
All right, so turning back to Exhibit 9, Sun Exhibit 9. You wrote an email back to Mr. Moore on August 28, 2015, and you listed these concerns, your initial concerns. You said, before we're willing to talk about the solar array on the Boudreaux's property, we have these concerns, and we want them addressed before we'll even get into whether or not we're going to discuss any aspect of array going on the Boudreaux's land. True?
That's true.
And so you had a series of questions there, correct?
Correct.
And Mr. Moore, 3 days later, emailed you back and responded to those questions/concerns, did he not?
That's correct.
Okay, let's go through his response. So,
I'm going to object to this. Mr. Berger's reading extensively and I believe unnecessarily from this item, which is already admitted into evidence, and the content is already
in very limited sections, and it is cross-examination, and it's directly contrary to what she said in her pre-filed testimony.
If you could just get to the
Sure.
to the point.
Thank you. So, he wrote you, I've tried to provide more information related to your questions. I've also attached a layout, so he gave you a second layout of the proposed solar plan on August 30th, all right?
A new layout.
Yeah.
Exhibit Sun form.
Of the potential project. Please do not focus on the specific location of the array. We are both open to screening measures and/or moving the array further west or east. The shape is somewhat flexible, but we need to avoid the wetland and the buffer around the wetland. And then he indicated that they strive to work with the neighbors whenever possible while respecting the host's right to do a permitted installation on their land. Right?
That's correct.
And so if you would turn to Suncommon Exhibit 10. And on September 1st, you emailed back to Mr. Moore, and you said, though we support solar energy and love the idea of a CSA for solar array and intend to have solar reinstalled on our south-facing roof, we do not want to look at it from our backyard. So that was your view. You just didn't want to see the solar array whatsoever, true?
That was one position, yeah.
All right. And then he had indicated in both of the site plans that they were willing to put in screening, shrubs, and somehow otherwise provide some mitigation for your view of the array, right?
Possible screening, yeah.
And you wrote in September 1st, we do not care to have shrubs or trees planted to block the eyesore that block our pastoral and mountain views. So you didn't want to talk about shrubs or trees at the time, right?
As the only issue, yes.
And then Mr. Moore responded on September 10th, and he says, we've spoken with the Boudreaux's, spent some more time looking and visiting the site, and they would like to move forward. And as the land slopes away to the west and then flattens, it seems like placement of the array of the Boudreaux's land pushed to the west might allow it not to obscure mountain views over the Boudreaux's land better than their earlier draft design I sent, trying to keep it as far north as possible. I understand that this email is not what you wanted to hear, but I hope that even with that said, we can get your input regarding siting and possible landscaping of an array. I would like to meet with you at your place to discuss the best possible location and potential landscaping that also might be helpful. Are there days of the week or times of the day that would work best for you to meet, right?
Correct.
Okay. So he asked you again, can we meet to talk about the best possible location and potential landscaping that you might find helpful, right?
For Suncommon 4, yes.
Yeah.
Exhibit 4.
And so contrary to your pre-file testimony, there were several occasions where Suncommon reached out and said, can we talk to you about landscaping, true?
Where in my pre-file testimony are you contradicting? Could you point to a page?
Sure. Page 18.
So,
We,
go ahead, I'm sorry.
Sure.
Point to it.
yeah, we were never scheduled to meet with Suncommon. We never discussed landscaping with Suncommon or our
Sure.
neighbors. They tried to discuss it with you, right?
But my answer wasn't they tried. My answer was in rebuttal to their application, which they said we did discuss, and I quote in my testimony.
Well, well, you just talked about how they said, we do not care to have shrubs or trees
No, if
planted.
you look at my testimony going down to page 18, lines 13 and on, they said we did. We exchanged numerous phone calls, which was not true, and discussing the project. We never did discuss it.
Well,
So as you
Mr.
just
Pepper-
stated, we
Mr. Pepper
said,
called you, right?
but that wasn't multiple emails discussing the project.
Well, the only reason you didn't discuss landscaping is because you were adamantly opposed to the project under any circumstances, true?
But I didn't say we did discuss it, correct? So my testimony is we did not discuss it. Their
And-
testimony was they did.
And in fact, in the application, which will be in evidence, Suncommon said, to further accommodate the abutters to the east, Suncommon is open to landscaping an approximately 250-foot expanse space in intervals east of the array so that when fully mature will create a natural display in concert with the existing landscape. In other words, they continue to say, we want your input and we will do landscaping to mitigate the view of the arrays, right?
For the Sun 5, is that what you're referring to in the application?
Sure, some five, right?
Ask your question again.
Sure. Once again, through their application, Suncommon reached out and said, we still want to do whatever is reasonable in the way of landscaping that will make our neighbors, the Allen Howell family, satisfied. True?
Yes.
Okay. And your response to that, Exhibit 21, please. You wrote a letter to the Public Service Board on October 22nd, 2015.
This isn't part of testimony, though. I'm seeing this for the first time.
Can you answer my question, please?
Well, actually, you have to cross-examine based on the testimony, so this isn't part of testimony.
It goes right to the testimony. Could you,
But this isn't part of my testimony. This is an extra document that I didn't have a chance to comment on my testimony.
All right,
And I'm seeing this for the first time here.
wait a second.
And this wasn't brought up this morning as a cross exhibit, so I'm just looking at it and absorbing it, so maybe we could all take a second
Sure,
to look at
she
this.
take the time to read it.
Correct, but this isn't part of my testimony for these procedures. And we're being cross-examined on our testimony, correct?
I'll also object, it was not raised, we just had this discussion about the joint hearing exhibits and what was in the administrative record, and I don't.
This is cross-examination. It's the intervener's own written letter contradicting some of her pre-filed testimony, and it's directly relevant to the issue before the hearing officer.
Can we take a moment?
Sure.
Lisa, you stated an objection, could you elaborate on that?
Just that it hadn't been disclosed as a cross exhibit, and when we were in discussions regarding the joint hearing exhibits, that had also not been disclosed.
requirement to disclose the documents to be used in cross-examination, and it's written by the interviewer.
I guess, well, let's see where the line of questioning goes with this, and,
So, Ms. Allen, so the application is filed, right, on October 8th of 2015. You receive a copy of it.
Correct.
And you see that Suncommon's committing to the Public Service Board that it wants to work with you on potential landscaping that would address your concerns, create a natural display, right?
It would address one of our concerns. The totality of our concerns was not relegated to screening.
Oh, okay. And you, on October 22nd, 2015, wrote a letter to the Public Service Board of Vermont.
Correct.
Yes. And you wrote there, quote, "We are also opposed to the shading they have suggested, which would simply block the very view we bought the house to see," right?
Correct.
Okay, so you were adamant that you didn't want to talk about landscaping, shading, or whatever, you were just opposed to it.
Again, if the totality of our objections were only screening, it would be an advantageous conversation. But as outlined in our motion to intervene, our objections far exceeded screening.
The Indiana bat, et cetera, is that what you're talking
Well,
about?
more than that, the historic accuracy as well.
Okay. And so you're not, you're satisfied with the Apple plan that Mr. Lawrence came out with, Suncommon Exhibit 12, attached to Suncommon Exhibit 12 as a reasonable step to improve the harmony of the project in concert with the surrounding area, correct?
Unfortunately, we don't have a choice but to be, because we're relegated to only talking aesthetics at this.
So the answer is yes.
When the scope of our issues are reduced to screening only, then yes, we have no choice.
All right, thank you. And so Exhibit 21, again, your letter to the Public Service Board in response to the application by Suncommon was, it ended with basically, well, not just a threat, it was clear. Quote, "A letter was sent by our attorney, Peter Langrock, to the Boudreaux, as well as to Suncommon, that we will pursue a lawsuit if this goes through. Please deny the certificate of public good for the said property." Did I quote that correctly?
You did, I read it.
We offer 21.
the objections.
The objection stands.
I'm gonna admit this, exhibit 21. Called Sun 21.
And so we're clear, as applied for, the solar array was in fact further west because it went from a 300 kilowatt to a 150 kilowatt proposal. True?
No, not actually true. The Suncommon 3, Suncommon 4, Suncommon 5 has the bulk of the array in the same position. Moved in Suncommon 4, as already stated, a little bit north. Suncommon 5 stated a little bit west and south, but the bulk of it retained in our direct view shed.
And so you said if you give the CPG and if they install it, we'll sue them, basically.
Yes,
Yeah.
that is stated.
Okay. And then you received what's been marked as Exhibit 100, I guess. Excuse me, the exhibit from the joint exhibit. 3. Do you have a copy of that handy?
Rebuttal comments dated December 7th.
I'm sorry?
Rebuttal comments dated December 7th from Suncommon.
2015.
Correct.
All right. And
2014. 2015, correct, yeah, I'm sorry.
it's a typo on it.
I'm a year ahead behind.
No, it said 14, but it's a typo. And so there they provided as Exhibit C a new site, which is some 550 feet from your property at a lower elevation and as far north as they could possibly get it, right?
They offer, but they don't remove the previous location, Exhibit Sun 5.
Did you read, and I guess you must have, that they have now proposed moving the site to what's marked as Exhibit C to that filing with the PSB?
Without amending their previous application, it is still as stands an application
I
for
didn't ask you for
Exhibit
legal
Sun 5.
opinion. I asked you.
No, that's the facts.
Okay, did you receive their
That they're proposing, they haven't
That's right,
changed.
to move the project to
Correct,
where we're
they've
talking.
proposed, yes.
I'm sorry.
Suncommon,
You have to wait till he finishes.
Suncommon one,
Two
right?
people are talking at the same time.
Sorry.
Okay. Now, we know that from what we've gone through, that Suncommon suggested a willingness to discuss landscaping with you throughout the process here, right?
For Exhibit Sun 4 and possibly Exhibit Sun 5.
Well, even when they submitted their, the current plan, they never said they weren't gonna talk to you about landscaping if you would meet with them or talk to them, right?
Which current plan, Exhibit Sun 1 or Exhibit Sun 5?
Sun one.
Where does it say that they're willing to talk to us? In their rebuttal comments?
Yeah, were they willing to talk to you? Did you ever pick up the phone and say, Mr. Moore, can we now talk about any type of landscaping that might make me happy?
So the process
Yes?
doesn't work like that for the
Okay, did you pick up the
PSB.
phone?
No, I did not.
Did you send an email?
We sent rebuttal comments to the PSB.
So you weren't willing to even discuss landscaping?
I don't think that's accurate. For Suncommon 1, that's not an accurate statement.
Well, what did you do to try to generate any discussion about landscaping as to Suncommon one?
We paid a landscape artist to develop a
I'm
plan.
not talking about June, I'm talking about when they filed this back in,
You're not asking a time frame. You're asking what did we do, and that's the result.
when they moved the array, the proposed site of the array to the far north, 500 and 600 feet from your property, did you make any effort to pick up the phone, send an email, or reach out to Suncommon to say, okay, now that you moved it all the way over here, we'd like to talk about some possible landscaping that might satisfy some or all of our concerns? Just yes or no?
No.
And in fact, even after they moved the proposed site, you continued to insist that landscaping wouldn't work and you didn't want it, right?
They didn't move it. That's not accurate. They proposed to move it.
So even when they proposed to move the site to what we're talking about
We
today?
did send in rebuttal comments, yes.
And you said, we don't want landscaping, we don't want it there, true?
Correct. That's one of the issues.
And where's the few options for landscaping that you claim to have offered Suncommon?
Correct. So Exhibit Sun 12 was an email. I believe you have this Exhibit Sun 12
Yep.
from Attorney Hill to Attorney Wonderly, am I saying that correct? Wonderly?
Yeah.
In which there's a site plan, a landscaping plan developed at our expense by Mike Lawrence, and the options are listed by Attorney Hill in the very beginning of that email, stating either apple trees or evergreens. Our preference would be apple.
Okay. In fact, according to Exhibit 12, Ms. Hill's email to Mr. Wonderly of June 1st, 2016, you opted for the apples.
We said that's our preference, but there's two options, the evergreens and the apples.
Okay, I'm just quoting it. Dr. Allen
That's a
opted for the
preference.
apples.
That's a
All right.
preference.
And that would be reasonable steps on the part of Suncommon in your view.
I don't know.
Thank you, that's all I have.
I already jumped the gun. Just a quick clarification, those email communications between you and individuals from Suncommon were all prior to their filing their PSB application, is that correct?
Correct.
And so that was prior to you seeing the exhibit that's now Sun, is that correct?
Correct.
And at the time, with exhibits, with the prior site plans, those prior site plans all proposed the array directly behind your house, is that correct? Directly west of your house?
Correct.
And they would, in fact, in your view, have dominated that landscape out in your backyard at that point, is that correct?
Correct.
Thank you.
Thank you. Here, excuse right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Kelly, you have an item before you that's marked as the pre-filed testimony of Charles Kelly. Was that testimony prepared by you or at your direction?
It was prepared by me.
Okay. And if I were to ask you these same questions today on direct, would you respond in the same manner as you have here?
Yes, I would.
Okay, and is there a correction, is there a technical correction on the testimony you submitted?
No, I didn't see anything technically. Retired engineer, I would just say that I still
I'm sorry,
hold
I'll draw your attention to
active license.
page 5, wasn't there a typographical error that we need to correct?
Yep.
Okay, and so as submitted, it had stated on line 10, the vantage point of your property, and that referred to the Allen property, is that correct? Okay.
Sorry, what was the answer? You said, and I just need a verbal answer.
Yes.
Thanks.
And appended to your testimony, you also see exhibits Allen CK01, Allen CK02, and Allen CK03. Are those items with which you have personal familiarity?
Yes.
And-
Could I just page for those things? Yes, I have.
And were those, do those items support and are they referenced in your pre-filed testimony?
I believe they are in different answers to different questions.
Okay, then I would move the admission of the pre-filed testimony of Charles J. Kelly Jr. P.E. together with exhibits CK01, 02, and 03.
May I inquire? Mr. Kelly, you're a member of the Addison Planning Commission?
Yes, but I'm here as a resident of the town of Addison.
So we're clear, you're not here in an official capacity?
No, I'm a fact-finding today. I will report back to the Planning Commission and the Select Board.
You're here because you're trying to help Ms. Allen oppose this solar array? Yes?
Not incorrect.
What's that?
Incorrect.
Okay, well, how many, are you here to help her?
I'm here to help her at her request to look at the site, look at the aesthetics, look at the applied critical thinking from an engineer's viewpoint as to is it properly positioned and sited.
Okay, so just if you'd answer my question, you're not here as a representative of the town of Addison because the town of Addison did not take a position adverse to this application, true?
That's true. Yes, okay.
And you've attached some documents, and reference documents, including a draft town plan, right?
Draft, yeah.
And what is a draft town plan?
Pardon me?
What is a draft town plan? Is it adopted yet?
Well, I think they used the word proposal, but it's a 123-page document.
Answer my question, please. Is it been adopted by the governing body of the town of Addison, yes or no?
No, it has not.
Same with the screening of solar facilities. Did you write this in-term ordinance?
No, it did not.
And was this in effect when this application was submitted by Suncommon?
I believe not.
Has it been adopted as of today?
You're talking about the ordinance?
Yeah.
That ordinance? No.
So what you've submitted as part of your testimony and incorporating your testimony is an ordinance that's never been adopted and a town plan that's never been adopted, true?
That is true.
And I'd object, not only for the reasons indicated in our original objection, but these have no probative value whatsoever. They're not operative documents, and even if they were adopted, they're not operative documents, and even if they were adopted, subsequent to the application and where we are now, it wouldn't be applicable to this application. One Vermont statutes annotated, section 214, subpart B, flatly prohibits application, even if they had been adopted, which are not. And in reference to that, I cite the Godnick decision by the Vermont Supreme Court applying that rule, 162 Vermont 588, 1994. It's zero probative value or relevancy or admissibility. We'd object to his testimony, we'd object to these exhibits.
The objection is noted, and it will be ruled on subsequent to this hearing. If any other questions?
Oh, yeah, question, is this admitted?
Oh, we haven't admitted it. I said you haven't ruled on it, on the admission of the testimony yet to proceed with us.
Exhibit 43.
Yes, the objection is noted, and you may proceed to this.
Sure.
Like, could you please note on the record that it's been accepted subject to the, it has been admitted into the record subject to the, I don't think it was ever noted that it was admitted into the record, am I correct? Or did I
It's not being admitted at this time.
It's not being admitted subject to the objection?
That's right. It's not being admitted subject to the objection.
I'm confused. I thought it was being admitted subject to the objection being ruled on later.
Let's take a 5-minute break and
Okay,
we can confirm that.
I'm
Yes.
sorry. Thank you.
Thank you. And it will be, because the objection is pending, and the objection will be ruled on in writing after this hearing. And that also, yeah, so the cross-examination should continue as though it were being admitted.
Thank you. Mr. Kelly, good afternoon.
Yes.
When did you first begin trying to help Ms. Allen oppose this project date?
She first came to one of our planning commission meetings and explained the situation. And I can't give you an exact date on that. However, she came back to a later meeting and said that she had filed an intervention. And whatever the date of that is, it was very close to that time. That was her second meeting.
So you weren't...
And subsequent to that, she was looking for somebody to testify. And she called me on the phone and I said, you know, I have an interest in this.
You have an interest in what?
In the proceedings here, so that I can report back to the town planning commission and select board for the process.
Well, let me ask you this. You're known as pretty ardently pro-nuclear power, fair to say?
Why would you say that?
Well, did you repeatedly blog and write in support of keeping Vermont Yankee open?
Is that relevant to this discussion?
Would you assure...
I'll answer the question.
Sure.
Is it relevant?
The way it'll work, Mr. Kelly, is I'll ask a question, and if you would answer it, and if you can't answer it, just tell me and I'll rephrase it, all right?
Mr. Berger, is this another cross exhibit that we haven't seen yet?
Correct.
Okay, so let's take some time to take a look at it before.
Well, they're not going to be, this is just, they're not big cross exhibits, they're not substantive on technical stuff, it's just statements Mr. Kelly's made over the years.
I'd like to take a few minutes for us to all look at this and before you continue with your questions.
On exhibit 43. So just back to my...
I'll object to this line of question on both relevance. It's outside of the scope of the direct, and it's wholly irrelevant to the matters before the board.
Bias is always relevant as to any witness, including positions, leanings, et cetera, and express views on various issues, and we're going to cover those very briefly, not going to spend a lot of time on them. His strong views as he's written on both nuclear and anti-solar. I think the hearing officer should hear just briefly what he's written and said in the past.
Okay, I'm gonna let this line of questioning continue and go ahead.
Thank you. Back to my question, Mr. Kelly. You've expressed views publicly in support of nuclear power, correct?
Correct.
And in support of Vermont Yankee.
Correct.
And you have written in various blogs, publications, something called VermontWatchdog.org, all in favor of nuclear power. True?
I have to look, I don't think it's more than maybe 2.
All right. And you've also written and spoken in numerous settings against solar power, right?
In I'd say a facetious way of saying that it hasn't been thought through well.
Oh, you've written multiple times offering criticisms of solar technology, environmental issues, electrical generating issues, grass fires under arrays. You've written to a number of sites deriding or opposing solar arrays, true?
I want it done right, sir.
Please answer my question. True?
I've written, yes.
Yeah.
I don't go all the way that you go.
Well, you wrote, and I quote, that, will the PSB get down in the trenches with the firefighters needing to extinguish grass fires under the arrays? Is that, remember writing that?
That's true.
Okay. Or climb on rooftop arrays, risking electrocution from the
That's
solar
true.
system. Right. So these are your views, your personal views, right?
Concerns, yeah.
Yeah, and you've expressed them repeatedly in public.
Not repeatedly.
What's that?
Not repeatedly.
You've even accused the Public Service Board of engaging in unconstitutional conduct on the issue of solar, have you not? They violated due process. Remember writing that?
Mm-hmm.
Yes?
I'm sorry? I need verbal answer.
I'd like to see the document.
Just answer my question, please. You've said that, have you ever said the PSB has blatant disregard of the procedural due process clause in the U.S. 5th and 14th Amendments, and I quote.
I can't confirm that.
You show Exhibit 46 to Mr. Kelly, please.
Could you present, are there any other exhibits that you intend to present in this line of questioning? I'd like to take a look at everything.
Sure, only if,
together.
I was only going to use it if he denied saying it, that's what I'm not. Those are your public hearing comments, right? For a legislative committee?
Can I take a second?
Sure.
Do you have a date for this?
I don't, but did you deny saying any of this?
I don't know, I want to see the date in the publication.
Do you recall appearing before a...
The words sound like some things I say, but I can't say that this is.
Okay, so let me ask you...
Mr. Berger, I think you've established the point.
Thank you. Have you accused the PSB of applying, quote, catch-22 logic?
Where again did they come from?
The Addison County Independent comment?
Could I see a copy?
Sure. Exhibit 47?
And again, object, this is just getting cumulative. I think the point's been established and acknowledged and.
Are you moving to admit,
need to.
are you
if he denies saying it, I suppose.
Why don't you answer the question and, let's move along.
All right.
Quite honestly, I'd have to go back into my computer and see what I've got there.
You don't deny writing that, though?
I can't either deny it or confirm it.
Does it sound like something you might say or write?
That's not relevant.
That's not for you to decide.
I'm not gonna give you what ifs.
Answer the question, please. Does it sound like something you would have or did write?
Does it sound like something I would do? Maybe, maybe not.
You, tell me what glare analysis you made in this case.
So are you moving to admit these?
Yeah.
43, 46,
Sure.
and 47?
Sure.
Priscilla?
I'll object. I think Mr. Kelly's testimony was that he couldn't, actually, I'm not sure there was confirmation on 43. In regards to 46 and 47, he indicated that he wasn't, could not confirm that they were his and would need to check dates or his computer to confirm them. So I'm not sure that, I'm not seeing anything here that, certainly with regards to 47, that indicates that this is the same Charles Kelly. In a response, and 46 is not dated, signed. I don't know where it came from.
I already admitted that he said it, but whatever, the testimony's fine.
43?
43, I didn't think that there was, I didn't think that he had testified that that was in fact his piece, I'm not sure. Yeah.
Okay, I'm not going to admit any of these 43, 46, and 47, and I'd like to move on.
Thank you. So tell us the glare analysis that you conducted in this case.
I didn't conduct it.
Is it true that
I
by...
didn't say I conducted it. Where's that coming from?
I'm asking you, did you conduct a glare analysis? Yes or no?
No, you said, tell me the glare analysis you conducted. I did not.
Thank you.
I object to your phrasing it that way.
Photovoltaic devices are made to absorb as much light as possible and to reflect as little light as possible, true?
I think so, yeah.
And because of this, essentially all of the light that passes through the front surface of the module is trapped in the layers below, true?
I don't.
And glass on solar arrays can be treated with anti-reflective glass to very much minimize any possible
Are you
reflection.
teaching me this, or where are you
Well,
going?
you listed yourself as a professional engineer. Do you know the answer to that question?
Ah,
Do you know the answer to that question?
I have an opinion of it, yeah.
Does anti-reflective glass, is it designed to reflect less light on a solar panel?
It's true.
And the panels proposed here are anti-reflective, are they not?
I don't know what the panels are.
Can I see Exhibit 31, please? Let me ask you, did you make any effort to find out before you testified?
It's the first time I've ever seen the name of the panels that you're using. That's interesting.
Mr. Kelly, did you make any effort to ask or find out what the name of the panels are and whether or not they're anti-reflective?
No, I did not.
You'd offer Exhibit 31.
I object. This is a letter seen for the first time here. It says, to whom it may concern. It's signed by someone who's not here in evidence, and it doesn't say that it has anything to do with this case. I don't know what this is. Some letter from Kyocera Solar?
It's the panels utilized in this project, and it's consistent with
Is
the
it stated on the drawing?
rebuttal testimony already in evidence by Mr. Moore.
Can you point me to where it says that these are the panels that are going to be used?
testimony about it?
Are you looking to James Moore's rebuttal?
Yes. Rebuttal testimony doesn't identify him by name, but at page 5.
On the, may I? On the site plans, if I may, look at those.
I would point out that on Sun 1, it does say module, Kira Serma 265.
Thank you.
So, that's the reference.
Thank you.
So I will still object to this. It's beyond hearsay. This is a letter from someone who's not here to testify, addressed to whom it may concern, which is not an entity here to testify. It's effectively substantive evidence bolstering Mr. Moore's testimony that should have been attested to and incorporated.
It's well within Title III, Section 810 for rules of evidence. It's consistent and correctly ties into Mr. Moore's rebuttal testimony, and it's offered simply to support testimony offered in cross-examination of witness who speculated as to the possibility of glare without making any effort whatsoever to either analyze it or to measure the nature of the panels of the windows.
I'm going to sustain Ms. Hill's objection and not allow the letter in.
That's all I have, Mr. Kelly. Thank you.
He has no questions.
I should interrupt to say, I do need to strike the testimony for the reasons I've already outlined in my objections to it as supported by what the hearing officer just heard.
And I'll continue my responses to this. I don't have any further. So Mike Lawrence.
Do you swear from the penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Mr. Lawrence, would you just state and spell your name, please?
Michael Lawrence,
And spell that last name, please?
Lawrence.
Thank you. And your profession, sir?
Landscape architect.
Okay. And you have in front of you a document identified as the pre-filed testimony of Michael Lawrence. Was the content of that document prepared by you or at your direction?
Yes.
And if I asked you the same questions here today under oath, would you in fact respond the same as you did in writing?
Yes.
And appended to that testimony are number of exhibits labeled Allen, A-L-L-E-N, M-L for Mike Lawrence, 01, appears to be a CV or resume. Allen ML02, Allen ML03, and Allen ML04, which are entitled Options 1, 2, and 3 regarding landscape screening. Did you, in fact, prepare those, all 4 of those exhibits?
Yes.
And are those exhibits referenced in and supporting your pre-filed testimony?
Yes.
So I would move the admission of the pre-filed testimony of Michael Lawrence together with exhibits Allen ML01, 02, 03, and 04.
No, that's it.
They're admitted?
You ready, sir?
Good afternoon, Mr. Lawrence.
What time is it anyway?
It is 1 o'clock.
Okay.
Right there.
Good afternoon then.
Am I safe in assuming this isn't the first time you've worked with Attorney Hill in opposing some aspect of a solar array?
That's correct.
So you've done that several times?
Yes.
And on every occasion, have you found some undue adverse impact?
Yes. Yes.
And you, of course, have read the Public Service Board's procedural order in this matter entered on April 7th, 2016, I assume.
I don't recall exactly what that is.
That sets forth the scope of what this technical hearing concerns.
I actually have not read that.
And do you understand that the sole issue set by the Public Service Board in this case is whether the applicant has taken generally available mitigating steps which a reasonable person would take to improve the harmony of the project with its surroundings?
Do I understand that that's a procedural order? If that's what you're telling me it is, and I would believe that. Yes.
Thank you. And you would agree that the Queechy analysis, as reflected in the board's controlling rules, doesn't require a solar project to be hidden. True?
True.
And you, of course, recognize that applicants are not required to abandon a project if some adverse scenic impact cannot be mitigated.
Certainly.
And you understand that the applicants are not required to completely harmonize their projects, true?
I would say they need to make a good faith, a reasonable effort, I guess is the, would be the operating words that come to my mind, that they are required to do that.
Well, actually, just if you stay with my question, do you agree that the applicants are not required to completely harmonize their projects?
Completely harmonize. Okay, I agree.
You agree with that? And so the relevant inquiry, again, is established by the Public Service Board is what steps a reasonable person would take to improve the harmony of the project with its surroundings, correct?
Yes. I would put a caveat with that too, though, that a project may not, they may take some reasonable steps, and someone may still consider it to still be objectionable. So I think there's definitely some back and forth room about what's acceptable and what isn't.
Right. But the key language is improve the harmony.
Yes.
That's all. That's all the rule requires, right?
Yes, that's correct.
Right.
But
And-
may I add, I think that you can improve it, but not improve it enough to give it a passing grade.
And you can improve it, and some people are just never going to be satisfied if they're an abutting neighbor, for example, right?
Well, it depends on where you live, I think.
Or what their attitude is.
Yeah, and what you're proposing.
Or what their attitude is.
Right.
Right?
Exactly, and how big the project is that you're proposing.
So, you were asked in your pre-file testimony, you say that Ms. Allen and Attorney Hill asked you to discuss the aesthetic impacts of this project, and I quote, particularly regarding the portion of the Queechy analysis related to whether the applicant has undertaken commonly available mitigation measures that a reasonable person would undertake to harmonize the project to its surroundings. Remember
Yes.
that?
That's, I'm a landscape architect, that's usually the one that I get.
Okay. Now, but the board rule 5.109A2 doesn't use the term harmonize, does it?
It's the Queechy analysis, which the basic undercurrent of and the foundation of the Queechy analysis is is the project in harmony with its surroundings? That's the, and in the context and in harmony with the context.
Okay, but listen to my question.
Okay.
Where does Board Rule 5.109 A2 use the term quote-unquote harmonize?
I don't know about the rules. I only know that the spirit of what they're into, what they do, is in the spirit of the Act 250 Queechee analysis. And I know the Queechee analysis a little bit.
Okay, but the important point for the board rule is improve the harmony, correct?
I don't know. As I'm saying, I'm not familiar with 5013C or whatever you're talking about.
Okay. And in fact, the board has rejected the use of the word or term harmonize in its analysis of Rule 5.109A2, correct?
I'll object, he's calling for legal analysis and conclusion. If Attorney Berger wants to argue the standard in his brief, he's certainly free to do so.
Just goes to whatever the standard is being utilized by this particular witness.
I'm having a hard time following where you're going with this. Could you kind of restate this again?
Right. You'd agree that applicants are not required to completely harmonize their projects. The relevant inquiry is whether they've taken reasonable steps to improve the harmony of the project.
And I'll object, and he's also misstating the language of the rule. But it's calling for a legal analysis, and he can argue that in his brief.
Well, give it 25, please. Exhibit 25 is a procedural order by the Public Service Board in CPG NMP 5978, and I just ask you to turn to page 27 if you would.
Again, I'm objecting to this. Now he's asking him to read legal decisions and comment on rulings of this board. That is argument for brief. That is not testimony of a landscape architect.
It's cross-examination of an individual that they call pre-filed testimony, and it goes to whether he understands correctly what the Public Service Board standard is relevant to the issue before the hearing officer.
The question of the correctness of the Public Service Board standard is a legal argument to be made in brief. It's not a factual argument to be made by the licensed landscape architect.
To let the witness understand the standard, he goes to the credibility or weight to be provided to the pre-filed testimony.
Okay, go ahead.
Thank you. All right, so you're with me on page 27?
I'm on page 27.
Okay, just, so the board there says, and I quote, "The relevant inquiry is what steps a reasonable person would take to improve," and they italicized improve, "the harmony of the project with its surroundings." Right?
Where are you reading? Just
Sure.
keep on this
I
first paragraph.
apologize. Is it okay if I lean over your shoulder? Sure. Sure. Page 27. All right. Right there, starting there.
The relevant
Okay, the relevant inquiry is what stakes.
I have to slow down. You have to slow you down a little bit. You're so fast.
I'm sorry. Court reporters such as Madam Reporter over here for years have yelled at.
Relevant inquiry is what steps a reasonable person would take to improve the hardship of its surroundings. It would say we must take steps to ensure that person are mitigated to the extent feasible.
So the focus again is improving the harmony, not on harmonization, right?
Well, again, if a project is so abhorrent, someone could take those steps and improve the harmony and it would still be unacceptable. But I agree that this language says what it says, and it's reasonable to make it a little bit better if you can.
Thank you so much.
All right. You're welcome.
Now, let's just talk briefly about Route 22A, because you mentioned in your pre-filed testimony as a quote-unquote, a busy, noisy road.
Right.
Which it is, right?
It is, and I was kind of amazed behind the Allen's house, the kind of sense of quiet that house helps set up back there.
So,
But it is a busy highway,
Excuse me one
yes.
second. You said it is, and I didn't hear the full question.
oh, I'm sorry, am I not speaking up enough?
I just missed.
Sure. Just, I want you to confirm, as you noted in your pre-file testimony, that Route 22A you described as a busy, noisy highway.
Yes.
And it's not a Vermont designated scenic byway, true?
I don't know.
If you go to the V-Trans site, that lists them all, right?
Well, it may not be. However,
Let me,
may I finish?
just, if you
May
would
I
stay with,
finish? Do I get to finish answering
You can
questions?
finish.
Or-
Go ahead, go ahead.
Okay, thanks. I know that I've been living in Vermont a long time, and I used to come back and forth from New York City, and I know when I hit 22A and I had those absolutely amazing views to the west, in my book, it would be a Vermont scenic highway.
okay.
Okay, but if it's not designated, it's not designated.
And you may think one road's a scenic road, and I may think another. Everybody has an opinion on what's a scenic road.
Absolutely.
All right. But it is designated as part of the Vermont truck network. Are you aware of that?
No, but I'm sure you're right. I wouldn't
Let me just
disagree
show you
with that.
Exhibit 37.
Yeah, I can see it's a Vermont truck road, yes,
All
thank
right.
you.
Okay. And it is a major north-south transportation hub for cars and trucks on their way to ultimately Route 87, the Northway in New York.
Sure.
And are you aware that V-Trans data shows maybe 3,500 vehicles a day going past the intervener's home?
I'm not aware of that.
Testifying here is in cross-examination based on testimony.
It's
He's putting new
cross-examination.
facts into
I
evidence
said it was
that was
busy.
nonsense.
And these cross exhibits are late in the game here. One second. I'm going to sustain Ms. Hill's objection and ask Mr. Berger to move along and not, just move on.
Yeah, respectfully, I'm just trying to understand, one of the issues that was discussed in this witness pre-file testimony is the view from 22A, and I'm just exploring 22A and what the public does or doesn't see. And part of that is relevant as to how fast and how heavily traveled and how much truck traffic, and I actually have a little video I'd like to show the hearing officer of cars whizzing past that site, so you can assess whether anybody traveling 22A would be in any way burdened or even noticed.
I'll object. This should have been put in through witness testimony. It could have been put in through rebuttal testimony. Mr. Lawrence's testimony is that the road was noisy and busy. If Mr. Berger would like to ask him what he means by noisy and busy, in his testimony he can do that. This is not cross-examination, throwing a bunch of facts that are not in evidence and that have not been seen by anybody at him, creating a video that we don't have a witness to attest to, and that was not provided in rebuttal or in exhibits before or even at the beginning of this hearing, is way out of the scope of cross-examination of this witness.
There's no order nor is there a requirement to provide exhibits that might be used on cross-examination. We would have been glad to, but it wasn't required. And we don't know what's going to be used on cross-examination until we start to cross-examine. And just to show,
Why don't you ask the witnesses some questions, Mr. Berger, and refrain from litany of facts and figures. If you have questions to ask the witness, that would be fantastic. I think we'd all love to hear them.
Sure. All right, let me show you Exhibit 38 and see if, do you ever look at...
Again, I object. This is just, and he's proceeding on with what he was doing, but asking about facts and figures that are not in evidence and that are, these are not cross-examination. He testified it was busy. He agrees it was busy. So this is not impeachment. This is adding facts into the record to bolster a statement that the witness already done. It should have been done in rebuttal or through a witness.
If the intervener is no longer claiming that the solar array as proposed would have any impact whatsoever on motorists on Route 22A passing that site, then I'll avoid a lot of this cross-examination. They're the ones who put it in the issue, and so part of, to analyze it through their landscape architect, is what is seen or would be seen or not be seen given the nature of the highway, the volume of the traffic, and the speed of the traffic. And it's perfectly appropriate cross-examination. But if they're waiving that as a claim, then they should waive it as a claim. Otherwise, this seems entirely appropriate cross-examination of their landscape architect.
Again, Mr. Berger can ask, what did he mean by busy? Does he know how much traffic there is? Does he know how long the views would be from passing traffic or the speed of it? Throwing evidences and a record in to, and it's not been put in through a witness and it could have been put in through rebuttal is just utterly beyond the scope of cross-examination and relevance and appropriateness for submission of evidence.
Okay, Mr. Berger, you can ask questions, but please do not present new evidence in the form of cross-examination exhibits. And I'll sustain Ms. Hill's objection and please continue.
Did you, Mr. Lawrence, did you try to look to see if passing motorists going through there at 50 miles per hour are ever going to be inconvenienced by the solar array as presently proposed?
Yes, I did.
Okay. And at 50 miles per hour, they're not even going to see that array, are they?
It's a glance.
And a lot of the traffic in that area is even going faster than 50 miles per hour, unfortunately, true?
Probably.
Okay. And also, motorists traveling both north and south of the intervener's home see different forms of solar on their drive before they ever get to or from the intervener's home, correct?
Yes.
For example, in your travels, you saw solar trackers in Addison right along the edge of Route 22A, yes?
Yes.
All right. And this is close, relatively close to the intervener's home, Exhibit 33, those solar trackers, you remember those?
Up the road, yeah.
All right. We offer Exhibit 33, copies please.
Describe what this is, please.
The witness just described it as solar trackers along the edge of Route 22A in Addison, Vermont.
Any objection?
Yeah, I'll object for the lack of foundation. I don't know where this is. I don't know who took the photo. I don't know when it is.
That goes to weight, not admissibility. The witness identified it without problem. He's seen it on his travels, right?
I know there are solar panels and solar trackers along Route 22A, yes.
Are you familiar with this image?
I'm not exactly sure where it is along 22A. There are several of these, so I'm not sure.
Sustain the objection. This will not be admitted.
In a 2-minute drive south of Ms. Allen's residence, there's a very large net metering project right on the edge of Route 22A, yes?
Yes.
That's known as the Bridport Solar Farm.
I don't know the name of it.
It's a 2.0 megawatt solar electric generating project,
I don't know.
and it has no screening, right?
I found it rather objectionable, actually.
But
Yeah,
it's no screening, does it?
that's correct.
And
No mitigation.
And across the street, let me show you Exhibit 50, a series of photographs, and ask you if that depicts the solar project just 2 minutes by driving south of...
Yes, that's the one.
We'd offer Exhibit 50, a series of photographs of that.
This is just one copy.
I don't see I don't see the relevance of this. It's not visible from the project area. It's not within the view shed of the project area. I don't see what it has to do with the aesthetics of this project. The fact that there may be another objectionable and unlandscaped project somewhere in Addison County is really irrelevant to the question of what the applicant did here.
The short answer is they've argued about 22A and its scenic beauty. Ms. Allen said about for walkers and for drivers and the claimed impact that this array would have on them. And they don't just exist in front of 7020 Route 22A. They're either coming from the north or coming from the south, where they're viewing various forms of solar, from solar trackers to 2 megawatt gigantic 9-acre sites before they drive past the intervener's home. And it also goes to the entire analysis, which is in part based upon what's the surrounding area. The surrounding area is not just one little area, it's the area in the vicinity where people live and commute and drive and are exposed to it. And so just like they get used to harvester silos when they first started in Vermont were objectionable, and now everybody likes them, people have accommodated and gotten used to solar arrays. And it's documented and shown right on 22A, both north and south of the intervener's home.
I'd say this is a huge leap into argumentation, and that argument is not in Mr. Lawrence's testimony, and had the applicant wished to present that argument that regarding the context of the environment, he could have done so through a witness, through his own landscape architect, and through evidence submitted arguing about the solar arrays elsewhere than on this parcel. So we had the opportunity to do so, certainly had the opportunity to do so in rebuttal testimony, in discovery, and did not do so, particularly in rebuttal testimony. If that's now the applicant's argument, is that the context and surroundings should involve other arrays elsewhere, then he should have presented testimony to that effect. I'll object
The
to
witness,
its cross-examination.
if I could, the witness's report talks about this, the industrial mechanical, I think we called it, reality of solar arrays. And that's part of his analysis of this case. And the point is, there's the so-called industrial or mechanical aspect to the entire stretch of 22A on both sides of the particular intervener's home.
That wasn't my argument, though.
But it's noted in his report. So
I
I'm just
didn't note it up and down the road.
No, I know.
Yeah.
But I'm just pointing out, it's ubiquitous in the area.
Okay.
But I'm hearing what she's saying, which is I think it was your responsibility, it was your landscape responsibility to make that point.
The witness's,
Excuse me.
it's cross-examination. It's supposed to be allowed to test the underlying basis for an expert's opinion and not be handcuffed.
I'm having a little bit of a difficult time seeing the relevance, so I'm going to sustain the objection and ask you to move on.
Since I read the tea leaves, I'm going to offer now a video from looking at the intervener's home with passing traffic. I don't want to waste time if it's going to be excluded, and I'd just like to record tape.
Objection and move to exclude. That should have come in through a witness. It should have been presented in testimony, and it's something nobody's seen before, but it should come in through a witness. You can't just put in effectively new testimony under the guise of cross-examination. That's far out of the scope. He's already, Mr. Lawrence has already attested that the road was busy and noisy. Attorney Berger had opportunity. Asked him a number of questions about what he meant by that and the traffic load. showing him additional testimony when we don't even have the witness. I mean, he's the videographer when it was taking somebody to lay the foundation for it is just far outside the scope of appropriate cross-examination and is not relevant.
Cross-examination by definition is quote-unquote introducing new testimony. That's what the purpose of cross-examination, whether it's in court or an administrative board type proceeding. That's the nature of cross-examination, as well as impeachment. That's what's done. That's what the rules of evidence permit, but whatever the hearing officer rules, so be it.
Cross-examination is supposed to introduce new testimony of the witness, though, not testimony of the attorneys. And so, if you can clarify how it's perhaps introducing Mr. Lawrence's testimony, I have no objection, but
I explained it, I think, as best I can.
I think that would be helpful.
Sure. It just goes to the overall sense of travelers on Route 22A, and frankly to the intervener's sensibilities as to solar and solar arrays. It's in the area. It's with no screening, with a very large site right on the edge of Route 22A with westerly views behind it, and as I'll go into, a historic home, an 1846 historic home across the street from it. It just goes to the cumulative weight of what we've been dealing with here as far as the intervener's objection to this arrest.
I'm going to sustain the objection and ask you to move on, please.
Sure. Mr. Lawrence, you agree that moving the location of a solar array can constitute reasonable mitigation, steps to improve the harmony of the project with its surroundings, yes?
Yes.
As well as reducing the size of such a proposal?
Yes.
Both of which have been done here, you understand?
I do understand, and I did make a point in what I wrote that when you're claiming mitigation, when you're taking something, that was what I would say, right in your backyard, I mean, really in your backyard, and sliding it to the side, that's very helpful. Leaving it where it was, to me, and I was imagining it there, because I didn't have all the plans and everything, but I was imagining that something could be out there that would be shocking and offensive to the average person. And so, it's good that they moved it, yes.
Or otherwise, do you agree that the current placement represents a reduction in visual impact from the original location?
Yes.
Now, and what you talked about a more machine-like, industrialized context to these solar arrays.
Yes.
All right. And I know it perhaps is apples and oranges, but Vermont and what its view shed provides has changed over the centuries, right?
It certainly has, and in
and-
different places quite differently.
And
some places it hasn't changed very much.
And I don't know if you were part of this, but when I was a kid, a lot of people in Rutland, where I grew up, couldn't stand the Harvestor silos because they were metal. They weren't either ceramic block or wood. And there was a lot of people who thought they were a blight or an eyesore on the Vermont landscape. Were you part of that discussion at all?
I never was part of that discussion.
But now, do you find them objectionable at all, the Harvestor silos?
No.
So people's sensibilities or sense of place change with the environment.
Let me think about that. I think maybe that's, that there's a grain of truth to that, and I think there's also, on the other side, there are things that are unattractive from the day one, and people never get used to them.
And in this case, for example, the Boudreaux could put a manure pit in their land, which would be perhaps an eyesore but allowed.
Yes, indeed.
Or a three-story barn right in the view shed
Yes.
of the interveners.
That's true.
Perfectly allowed.
Yes. But they couldn't put a Walmart in.
But as far as blocking the view, they could do a whole number of things far more
Yes.
obstructing than what these panels as presently located are.
Yes.
All right. And the proposed site is now, 600 or so feet southeast of the home?
Yes. Southeast of the home, it's northwest of the home.
And it's at a higher elevation, maybe 30, 40 feet higher, the home over the array?
I don't know, I really didn't have accurate topography. And actually, that's one of the, one of the things that kind of came in is I wondered why the proponents, why the developer, if you will, hadn't done some of that kind of study, that kind of topographic study.
But you do understand they would...
Because you say 30, 40 feet, how do you know that? I don't know that.
Well, I'm taking Mr. Kelly's pre-filed testimony for it.
Okay.
That's, okay?
Well, I don't know
That's
how
from
he
the
got...
geologic survey map.
Hang on.
Okay,
Okay.
okay, so,
You talked to me.
so in the, so really what your ultimate opinion in this case is that the addition of vegetation to help hide the solar array would represent a considerate approach to its historic neighbor that would be reasonable.
Yes.
Thank you. That's all I have.
Just a couple of quick points of redirect. Oh, actually, so that was not in there. So never mind. Just one quick follow-up question, Mr. Lawrence. Mr. Berger just asked you about other things that could be built on that property, and those things, to your knowledge, would go through land use review and siting procedures, wouldn't they?
Yes.
And the agricultural uses like a barn, would they be in fact consistent with the nature of that agricultural landscape?
Yes.
And would they be consistent in a way that the proposed solar project is not?
Yes.
And you said they couldn't put up a Walmart, is that
Yes.
correct?
Mhm.
And you're actually the landscape architect for Walmart, are you not?
Yes, indeed I am.
So you would know. And so if they were, in fact, if someone were to propose something like a Walmart there, it would in fact go through rigorous land use review and zoning or state Act 250 and
Yes.
so on. And you've been part of those processes elsewhere, is that correct?
Yes.
Thank you. I don't have anything else.
Thank you,
Thank
Mr.
you.
Warren.
Thank you.
And we were discussing after this break, the schedule for briefing, and we understand that it was in the schedule as 7 days after the.
Yeah, but let me, I just wanna make sure I have the exhibits all
Good idea.
straightened out. We were all on the same page. So as of right now, I just have joint 3 up here, and I'm waiting for 1, 2, and 4. And 23 is no longer admitted, it's replaced by joint 3. And then we admitted 40 and 21. And then Dr. Allen's exhibits pending the objections and, no, sorry. Those exhibits are not admitted, so I'm waiting to make the ruling on the objection.
I believe on Dr. Allen's exhibits that several of them were admitted, and I think
Yes.
there were 3 that were pending the objection. I believe you stated on the record that the remainder were admitted.
That's right, yes. 1, 2, and 8 were the objections, And 3, 4, 5, 6, 7, 9, and 10. We're in a minute.
So we need to run and get a copy of joints 1, 2, and 4. Do you have a clean copy for some?
Yeah, that's what Kendall's gonna grab right now.
Thank you so much. Mine are, they just hole punch, so they tend to jam up the machine, and I am cognizant of the public service.
I think we can give you the joint exhibits just by remarking things that I previously marked but didn't offer, so
Okay.
that's already in.
She said she knew. She said she only had to hear it.
Okay,
So one would be the October 8th application and your October 12th correction letter.
Yeah, I can't believe that the application came
I don't know if that's there or not, but
Do you have a copy of the correction?
Yeah.
1, 2, and 4.
Oops, got one.
I did when we started the day.
Yeah, I was looking for a pen. Okay.
So the answer is I did when we started, and everything was moving in its place. And now it's Yep.
Okay.
do we have 2 seconds to chat?
No, the ones that we have, they're in half. That's
they
what
are?
was submitted. Yeah, they're like half cut off.
Oh, okay.
Yeah, but this is the October 12th letter.
Just the letter, not
Just the letter. No, because the attachment, that's the whole application, right?
Hi,
The letter was just a letter, right, the one page. Oh,
video.
here it is.
Yeah.
It was a
Stand or something
corrected
for it?
page 4 of the net metering application. And then it's and there's the corrected page 4, so there it is. Yes, that's it. That was it. We've got the whole application, we just didn't have this.
I don't know.
No, I don't think so.
Yeah, it needs to be sticking to joint 1.
The idea is to
There,
add
to
to
stick
joint
to
one.
joint 1, yeah. Because they, like I said, they filed a correction, so it should be connected with it.
Oh, you got it. You
Just
just need
staple
mine.
to it. No, I found mine. Finally.
Yeah, I don't. There's a paper clip if you want to.
Oh, I'll just
Ad
do it.
hoc.
There we go.
Yeah, thank
Okay.
And it was just the one page?
Yeah, and it's
Front and
double
back.
sided because it's a
Okay.
correction to page 4, but I wanted to make sure that the corrected copy was in. So you've got joint 1, now you have joint 1, 2, 3, and 4, right?
Yes.
40, 21, and then the exhibits that were attached to everybody's testimony.
That's right. With the Charles Kelly exhibits and the Dr. Allen's exhibits 1, 2, and 8 are not admitted.
Pending
Pending the,
consideration.
yes, exactly,
Okay.
exactly.
So the others are, and then the exhibits to Mike Lawrence's and James Moore and
Those were all
Michael
admitted.
were all
I mean,
admitted. Are you good?
Yes.
Oh, you're good, we're good.
Okay. All right, let's go back on the record to discuss the briefing schedule. You had started to say something, Ms. Hill, and you went back to talking about the exhibits. Did you want to?
I probably did. I believe that the procedural order, we discussed during the break, council discussed during the break, the procedural order had a briefing schedule, and it runs, however, not on date certain, but rather from dates on which the electronic transcript was available. And I think during the break, we also had inquired of the court reporter, how we might most expeditiously be made aware of when they were available, and I'm not sure we should probably firmly state that, because I think the agreement was briefed 7 days after.
7 days after the electronic transcript's available.
And then is there a, was there a replying brief here? No, just one
No.
round of final. So, just how can we, so given the short, timeframe, how will we know that it's been posted?
So as of now, they just get posted as we receive them. So,
Could I suggest, do we really need electronic transcript to brief this? Maybe we get our briefing within 7 days of today, I mean, I don't think it's anything that complicated that requires a citation to the record. And most of the testimony came in pre-filed, and we know what it is. It seems we don't really need the transcript to brief this.
I think the transcript is useful and necessary, especially in regards to the fact that there were these other exhibits to be referenced, and the transcript's usually up within a week. It's not, I mean, it'll be up probably next week, I assume, so it's not a delay, and that way we can accurately reference. I know even though I take notes when I look back at the transcript, things are not what I thought somebody said, so just for clarity of being able to reference the testimony correctly. And I think the delay is not exorbitant. It's not like we're gonna be waiting months out for a transcript to be typed up. And it's what we had previously agreed on.
I said next week would be here. I don't know how quickly that's supposed to go.
Yeah. Okay, let's go back on the record. So, after discussing with the court reporter, looks like it would be 1 week from today when it would be available, and if it took a day to get onto the board's website, so I'd like to say that the availability would be the 18th of July, and this way we could set a firm date for the briefs to be due, if that's okay, and have it be 1 week after the 18th, which would be the 25th. Okay?
Sure.
And reply 1 week later,
That would indicate there isn't a reply.
or, sorry, I should have asked first, do we want an opportunity for replies?
I don't think we need it.
No, I think we had agreed to 1 round.
Okay.
Obviously, if the hearing officer wanted something responded to or briefed further, the hearing officer would be free to. So direct.
Indeed. Okay, so July 25th. And then earlier, we had discussed an opportunity for comments to be filed on the Division of Historic Preservation's comments, and that was the 21st. Thursday the 21st.
So I'm sorry, I was still a little bit confused about that because I wasn't sure if DHP was filing something further or not.
I think they are on notice that they may file something further, and if they do, then the interveners are welcome to include that in the comments. If not, then the comments on the most recent filing would be the target of the discussion.
So the 21st.
Yes.
For our code?
And as well, yes. Is there anything else to discuss? Go ahead.
Kendall,
I'm sorry, I just want to make sure I understand. So the division will file their comments on the 21st, and we'll file ours in the same time, or a week after that? Or I might just mean the same thing, but.
So the division has an opportunity to file comments. I asked that they file them by the 14th.
Oh, okay, that's,
Yes.
I misunderstood, I'm very sorry.
Yeah, no, that's good. And then, you know, they have an opportunity to comment, but if not,
They may not.
yes.
I understand.
Okay. Anything Anything else? Nothing? Okay. Thank you very much.